Yes.
Item number 12. Possible method or high calling. Responder number 5. Responder number 5. Posted is only research.
Item number 12. You want to withdraw? We'll see when the matter reaches.
May it please your lordship. Lordship, I am praying for listing of these two eviction matter, lordship. It was filed long back, lordship, on
Vision,
eviction matter, lordship. Eviction, lordship.
eviction. Okay.
It was filed on 8/1, lordship.
For admission.
Lordship,
For admission.
motion matter.
Of
No.
For the admission matter is urgent of it. 2021 matter. 11 or 13 any.
13.
Lordship, with regard to item number 51 of supplementary list, Lordship. Lordship, I have filed an IA for implement in this case, Lordship. That may be taken together, allowed to taken together, Lordship. Because I have not erred as party, Lordship.
We'll see when the matter reaches.
Lordship, one IA I have filed, that may be
I
IA for implement.
will see when the matter reaches.
Pray for listing of a matter for motion matter.
May it please your lordship.
Maybe on 11.
13th.
May it please your lordship. Lordship, I beg to mention for listing of writ petition in admission stage, your lordship. It was last listed on 7/10/2025, your lordship.
For
Your lordship, matters about the eviction of the petitioner from his Pata, your lordship. 13, your lordship.
next week.
Bless your lordship.
May please your lordship. Lordship, I have a similar prayer, lordship.
Next week.
Hi.
Lordship, I beg to mention a cash matter for listing. May it be listed on.
13th.
May it please your lordship, lordship, we seek adjournment for item number 1 since the senior is out of station and he thinks it's crucial that he
Item
argues
number
this
1?
matter, your lordship. Yes, your lordship.
You want an
Adjournment for 3 to 5 days maximum. Adjournment, your lordship, for 3 to 5 days, your lordship. Senior being out of station, he thinks it's crucial that he argues this matter.
item number 1 at the request of the petitioner. Was any instruction sought for in this matter? No. Why the matter is come? Huh? They are seeking time. No.
Lordship,
Next.
Or listing of a motion matter, urgent matter, unlisted matter, eviction related matter.
Unlisted.
That's for listing a matter which is pertaining to schedule of Jimma.
When?
It's supposed to be listed after 2 weeks, but not listed.
Okay, next week.
On Friday,
Next week.
next week. Motion item 1.
Who are you?
NH mother.
No. Who are you here? Everybody has a different case. Why you are filing one petition? You are asking for what? Allotment settlement of the land in question of so and so on the basis that you have certain right of inheritance, isn't it? Mr. Gogoi, Mr. Hendrik? Then how can you file one writ petition having everybody? No. This type of case cannot be allowed. You may have a case, but we cannot allow this everybody to come together. Everybody has come together.
Please, if the court allows for the senior to appear, your lordship, like later today, your lordship. I've been instructed to get it.
Earlier, these persons have come before this court.
Lordship,
Huh?
Annexer 7, Lordship.
Then? Yes, they have earlier come. What is the ground for which they have come?
Senior nine.
Earlier it is, my lord, they come for eviction, Lordship.
You see, Mr. Counsel, the problem which you are facing is this. When you are applying for pattas on the basis of having jot rights, maybe you may have, you may not have, that's a different thing. But you have to file an application. You cannot have a joint application for everybody. It has to be individual applications for everybody. Isn't it, Mr.
Lord,
How can on the basis of this document we issue a writ? We do one thing. You are otherwise protected from eviction by the court already, earlier. That if there is any move to evict you, they would do so by giving you 15 days notice and all. We close this instant petition with the liberty given to you to apply as per the provisions of the Act. You claim rights on the basis of the Assam Temporarily Settled Area Tenancy Act 1971. So each individual who is claiming right of inheritance of jot holders has to apply as per that. There's a form. You have to fill up that form. You can't come like this.
If I may just take a short pass for half an hour, like pass over if I may. The half an hour time if I may.
Half an hour time. Your senior is coming.
I think-
Yes, you get hold of him. Otherwise, by 12 o'clock, I'll take it up. Ask your senior to come, or this matter ends here itself. Should not be given another new date.
My application for PSC was rejected without showing any reason of reason. It's 14 months. Only the word rejected is written.
What is this PRC business?
That's
For
what they say,
Education purpose.
I have appeared in NEET, madam. And
Ah.
I have got all India rank, general category rank 20017. For that purpose, my lord, I need this. Yes, madam.
The reason is the circle officer has not recommended for issuance of the certificate.
Not recommended. Why it is not recommended?
Who is
Because
entitled
you
to a
are not
PRC?
Pleased to see the documents. I have sufficient document. What is the objection? 65 document I have annexed, my lord.
Okay. Let's issue a notice,
1970 portal is
issue notice making it returnable on 16th of March 2026. Mr. Who appears for the revenue? Ms. So-and-so appears for the revenue
I am for 2 and 3.
and Mr. S.S. Roy appears for the respondent number 2 and 3. The grievance of the petitioner herein is that the petitioner had applied for the permanent residence certificate, which the petitioner has to submit. For the All India Rank Bracket NEET, NEET examination. It is the case of the petitioner that the petitioner has all the documents, but for reasons best known, the respondents, number 3, have not recommended, and resultantly, the petitioner's application has been rejected. Full stop. The respondent herein, more particularly the respondent number 2 and 3, are directed to apprise this court by way of an affidavit to be filed on or before 9th of March 2026 as to why the petitioner's application has been not recommended and consequently rejected. Full stop. Pending notice, comma, the respondents, it shall not be a bar on the part of the pending the next date, it shall not be a bar on the part of the respondent number 2 and 3 to reconsider its decision on the application.
Good.
Contempt application. Contempt application. Today is the
What?
contempt petition. The direction was issued by to the circle officer, Lasivara Revenue Circle, to process the self-permission of the petitioner.
What is the direction?
What you will find page number 13, it is essentially direction, last 2 parameters. In view of the assertion made in the evidence opposition, the requisition is because on permitting the petitioners to apply for self-permission, land self-permission and other requisite for capacity to portal as required. On receipt of such application, the respondent authority shall process the same expressly in accordance with law and within the time provided for. Malad, thereafter, Malad, the order.
No, order, we are concerned with the order of 3/12/2025. Now, what is the direction passed?
Well, this is the direction.
What?
Direction was direct.
In view of the assertions made in the affidavit in opposition, the writ petition is disposed of permitting the petitioner to apply for the sale permission and other requisite through so and so. On receipt of such, the respondent shall possess the same expeditiously in accordance with law and within the time being provided.
Madam.
Now, they have not done it.
Not done it. There is a specific direction of the district.
Direction is when? 3/12. When did you submit this document? 16/12. And when did you file this application?
What happened earlier?
21. Then, what is there?
Earlier, the petition approached the school,
You had to submit What is the time period for giving the permission? No, 45 days is over. After your submission. You submitted on 16/12?
Date of application, my lord.
No. Absolutely no. Taking into account, in view of the assertions made in the affidavit, the writ petition is disposed of permitting the petitioner to apply for a late land sale permission and other requisite through Sevat Setu portal as required.
My lord.
So you have to therefore apply. After this order is passed on 3/12. 3/12, after that, this order was communicated by way of a communication on 16/12. 16/12, kindly see. Annex 14, page 4, 14,
16/12.
16/12. Now 16/12, that means on that day you have applied.
Application was made earlier, my lord.
You have to freshly apply. You have not freshly applied.
No, my lord, only once, self-permission can be applied only for once. My lord, what happens, my lord, earlier the petitioner approached this court, my lord, taking self-permission only on the basis of the manual application, my lord. The authorities, my lord, informed this court that I have to apply through online Seva sheet, during pendency of the writ petitions. That application was made on, my lord, Lordship will find, that I have given a category.
Mr. Counsel, read page 13, the last to one paragraph.
Within the.
On receipt of such application means you have to file an application.
Then, my lord, twice I only online Seva sheet application can be made only once. During pendency of the writ petition, I was informed by the other side that I have to apply for online through online process.
When did you apply for online?
My lord, that online application was filed. Lordship will find, my lord,
On 16/12.
no. It was made earlier, my lord.
Where? You must have got an acknowledgement? No. After this order, on receipt of such application means the application is to be filed subsequent to this order.
Then, my lord, again, I'll have to submit.
File.
Seva sheet application.
Yes.
Online Seva sheet application is pending.
Have you submitted the online application as per the Seva Situl?
Yes,
When?
during pendency of the writ petition. that
But
was-
this is the order. In view of the assertions made in so and so, further process is required to be done through a comparative level. It is stated that no application in the manner is found in the said portal and there is no averment to that effect. Now thereafter,
that would not be brought to the.
so therefore you seek a review? I'm not going to issue notice on this type of applications.
My lord, in fact, there is a specific.
What do you want? Dismissal?
There is a specific guideline.
Enough. Chalo. You have not filed an application pursuant to the order dated 3/12 or have you filed any application after 3/12?
But before three.
After 3/12 did you file? My question is specific. After 3/12/2025 have you filed? No. This is an application file alleging willful and deliberate violation to the order dated 3/12/2025 passed in WPC number 3664/2025. Full stop.
My lord,
It is very relevant to take note of. The observations made by the order dated 3/12/2025 passed in WPC number so and so and the relevant paragraphs of the said order is reproduced herein under a tick mark my issue. From a perusal of the said application, from above quoted order, portion of the above, from the perusal of the relevant portion of the above quoted order, it is apparent that the petitioner is required to file a fresh application in the Seva Setu. And the respondent authorities are to process only upon receipt of such application. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether any fresh application has been filed pursuant to the order dated 3/12/2025. The learned counsel submits that no application was filed pursuant to the order dated 3/12/2025. Considering the above, no case for issuance of notice in the instant proceedings have arisen, taking into account that the petitioner have not filed any application pursuant to the directions passed in the order dated 3/12/2025. Accordingly, the instant application stands closed. Full stop. It is, however, observed that the closure of the instant petition application shall not prejudice the petitioner to submit a fresh application in the seva setu seeking land permission, and in the circumstance such application is filed, the respondent shall abide by the order directions passed by the learned trial court by the learned coordinate bench in the order dated 3/12/2025 in WPC number 3664/2025.
Wherein I am aggrieved by the cancellation of my GST registration on account of non-furnishing of the bank details. I am aggrieved by the cancellation of my
বহুত
GST.
আৱাজ কৰি আছে ন এচি বহুত আৱাজ কৰি আছে What is wrong? Yes, your cancellation of what?
The GST registration. Lord.
When was it cancelled?
It was cancelled on 6/3/2024.
Huh?
6/3/2024 at
Then?
27.
What was the issuance notice issued? 6/3/2024. Notice was issued for
On
cancellation,
27th,
whereas on the basis of information which has come, it appears the registration is liable to be cancelled for Rule 21 person violates the provision of Rule 10A. 10A means you did not provide the bank
The
details.
bank details. Lord.
Then you are supplied to ask a notice. Then what happened?
Lordship, there was we did
Reference to the show cause notice area, whereas no reply. You did not submit any reply. Then
Lordship, thereafter it has been cancelled. I did not come to know immediately about this, Lordship. I had filed the returns until the date of cancellation, but I cannot, Lordship, subsequent to the date of cancellation, I cannot file my returns, Lordship. And I'm ready to
obviously you
comply-
cannot.
Yes,
Then
I'm ready to comply with all the requirements, Lordship, so if it may kindly be restored.
I passed one judgment now. What is there? Where is that judgment? You have a copy of it? Wherein there is a requirement of maintaining that he will be liable to pay all penalties and whatever may be. Where is that my judgment?
Something of similar line.
No, no, no. This is not my order. Where is my order? Let us issue notice, torture you for another 2 years by keeping the matter pending. What do you think?
This also says, Lordship, that I will pay all the due, pending.
No, no, no. Where is my order?
I'll bring that. I'll bring that.
Bring it, then we'll take it up. No, today itself. Then only. And but I think they should be
Lordship, it's there.
for 2 years.
For 2 years, there is delay. Lordship.
Then you don't have a right to come out here and get a notice, get it cancellation cancelled.
CDR has not been followed.
What procedure? What you have to do? Issuance of notice. You issued notice was received. Then so deemed service, whatever may be, the notice has been received. Regarding
But if I'm not complying with Rule 10A, Lordship, then the procedure says that I have to be furnished a notice for 30 days,
for
whereas I was furnished a notice of 7 days only.
no, this is for cancellation. 21AA CGS accounts. Where is that provisions? Let us see. CGST. We issue notice. Let it remain for another 2-3 years.
What is the order of?
No, you have come very late. You knew for the last 2 years you didn't have the registration. What is the urgency that on the first day itself this court should allow it?
And it appears during this period, he was doing the normal business, Lordship.
You were carrying on business. Yes, where is that? Rule 21A.
Rule 2A, Lordship.
Huh? 10. Furnishing of bank details after a certificate of registration in so and so have been issued, made available on the common portal, and a goods of service that has been assigned, and except those who have been granted registration under Rule 12 or Rule 7 within 30 days from the grant of the registration or furnishing of so and so, whichever is earlier for their remand. Provided that in the case of a proprietorship, the permanent account number shall be linked with the Aadhaar card of the proprietor.
Subrule
Where is the notice required that you have to do?
Subrule 2A of Rule 21A, Lordship.
Huh?
Subrule 2A. Rule 21A.
Where a
Clause B would be applicable. Clause B
where a
would
comparison of the returns submitted furnished by registered under so and so with the money is a contravention of the provisions by the registered person. Then
Clause B, Lordship.
clause B.
Yes. Where
Yes.
there is contravention of the provisions of Rule 10A by the registered person, the registration of such person shall be suspended and the said person shall be intimated in Form GST Reg 31, Lordship, electronically on the common portal or by sending a communication to his email address provided at the time of registration or as amended from time to time, highlighting the said differences, anomalies, or non-compliances and asking him to explain within a period of 30 days as to why his registration shall not be cancelled. The show cause notice which your lordship peruses is not under the, this is not Form GST 31, Lordship. It has been issued, Form GST 17 has been issued to me, allowing me only 7 days time, Lordship. At page 26.
But that might be a reason for suspension.
Cancellation, this is the procedure.
This is for suspension. Why the registration shall not be cancelled. Then why didn't you file an appeal?
Because the period has lapsed, Lordship.
Then why didn't you file a review? There is a provision by which it can be recalled also, no?
Revocation.
Revocation, cancellation of license can be revoked. Revocation 23,
Yes, Lordship.
whose registration is cancelled by a proper officer on his own motion, may submit an application for revocation within a period of 90 days. Why didn't you do that? Why?
I've made a statement that I came to know in September about.
Then why didn't you file an appeal under 107?
Because that period,
Go file appeal.
that period has lapsed.
So file appeal, they will consider. Better.
Lordship,
No,
there's a
yes.
Delay of only 1 month. They
What?
cannot condone beyond that. The delay of only 1 month makes condone.
That day I got hold of one judgment when on the ground of alternative remedy, this court sends it back, then the court will relax it under 220 by applying 14. That is one beautiful judgment on the question of insolvency by Justice Gavai. Wait, let me get it here. We should not allow this type of persons to carry out any business who is so careless.
Lordship will prescribe the conditions on which it may be restored, Lordship.
No, 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 no. Why should we allow all these type of things?
On the violation of this procedure, Lordship, there is also a
No,
judgment.
procedure violation is for appellate court to look into it.
There is a judgment of this honorable court where procedure.
Go before the division bench. And if it is division bench, go to the Supreme Court. What do you say, Mr. Chaudhary?
Yes, sir.
The Lordship has allowed on earlier occasion.
I am not going to allow this type of things. Hey, internet to बहुत बेर है. Not slow. Hey, interneter manuk talksun, why the net is slow? Huge amounts are being paid to these people and this internet is slow. How is it possible? Anyways, get hold of that judgment. Don't only. They have it after 1 month?
And we will not take it up the earliest.
No. The matter has been going on from 9/1/2026. Then to bring to on record the substantive their claims that some amount of the business is undertaken by the petitioner prior to the registration being cancelled, as they so and so appears on mere matter deferred to be listed, enabling to file an affidavit as informed. Affidavit filed.
Yes, Lordship.
Okay, you get hold of that judgment then only. And that too, when is that too, not only that, the reported one. You get hold of that, otherwise it matter gets deferred for 2 months. When the matter, I'm not sitting anymore here. Normally, when he gets it, we'll have it at 4:45. Last item of the day. Provided it is reported one.
Instructions were short.
What is this?
Like matter pertains to mutation. There is an order, Lordship will kindly come to page number 48.
Lordship, it was not done because the application fees was not paid. It was not done. Application fees to the only. बोलिए इसे the application that we filed there.
Who are you?
Fine.
Who are you?
I'm the title holder, my lord. Lordship will kindly come to the chair.
Huh?
I'm the title holder, my lord, of this land.
Huh.
This land was, the scheduled land was decided in the favor of our predecessors, my lord, by judgment order. Lordship will kindly come to page number 30, that is the judgment. They have to file an execution petition.
Whose suit it was? It was whose suit? You filed a counterclaim.
Yes, I filed counterclaim. My counterclaim was accepted in the title appeal, my lord.
Huh.
Lordship will kindly come to page annexure 4, page 30, my counterclaim was considered in the title appeal, and thereafter we filed execution that was also decided in our favor. Lordship will kindly come to page 40.
So this is the their direction which is given.
Yes, my.
Further directed that the plaintiff shall vacate and deliver the possession of the suit land within 3 months from the date of, from today. Then
we filed.
Then you had an execution proceedings.
Execution was done. Thereafter, my lord, we filed.
So it has been executed, now you're in possession on 10/1/2024.
Yes. Thereafter,
Then
we
what
filed
happened?
RTPGS, my lord.
Then you filed an application on 10/22/2025 for mutation.
Mutation.
Then what happened?
Then we filed application before ADC. Lordship will kindly come to page 47.
With reference, I would like to enclose here with the prayer petition. In view of that, you are requested to look into and take initiative as per the honorable court's decree and so and so. This is being given to the circle officer.
Yes.
Okay. And then also he has not done it. What is wrong with your circle officer?
Lordship, as per my instruction, Lordship, his application fees was not paid and there are some defects in the application. So the application we could not trace out which he had mentioned here, Lordship. That's why, Lord. And he has never approached the circle officer as per this instruction, Lordship.
Has he filed an application or not?
As per this, Lordship, he never approached the circle office. As per my instruction,
Means
Lordship,
he has to go and personally visit the circle officer.
no, Lordship, why the RTPS application was not considered, Lordship. the application which he filed for mutation, it was not found in our system. So he never approached.
Now, where is this? This particular application?
Application is, acknowledgement is there, but this
No, there is
acknowledgement,
an acknowledgement.
Lordship, but my circle officer says the RTPS portal circle, which may be due to non-payment of requesting fees or any uploading issue from the petitioner's side. At present, all RTPS applications are time-bound, extracted escalation to the higher authority in case of inaction. Again, his application was not found in our system. We have taken the.
So what is
acknowledge-
this number? This blank. Your application for mutation after deed registration has been submitted successfully on so and so.
But this application.
It is deed registration.
Mutation.
Mutation.
Kindly read page 46.
Mutation after deed registration.
Huh?
Your application for mutation after deed registration.
So deed registration is after sale deed.
Look, there was a sale deed. There was also a sale deed which was in our favor, my lord. And that was.
Understood, but didn't you apply on the basis of this cancellation of the name of somebody?
I will have to take instructions because this is online portal, my lord. They have submitted mutations.
No, my question is, you now claim that your mutation should be done on the basis of the decree passed by the court,
Yes,
and now you are in possession.
yes,
So therefore, did you file that application in that manner?
but it's online.
Where is your application?
Application is at page 47.
This is only an acknowledgement. Which is the petition
Page
application?
47, my lord.
This is to the Board of Air.
ABC. Page 47.
It can't be. Because see page 47, it has been signed on 14/7/2025. Whereas the acknowledgement is 22/2025. It can't be.
This was before ABC, not circle officer. This.
So where is your application filed before the circle officer?
Give me some time instructions on this.
What is this? This matter cannot go beyond this. 9/1/2026, this is going on. And he submits the wage instruction. No application has been found. Then
7, para 7.
you do one thing. You submit a fresh application within 15 days. They will consider within 30 days and dispose it.
Lordship, this will automatically within time bound, it will done, Lordship, because as per portal, it will done, Lordship. 45, it will take 45. If there is some objection, then it will take more than 45 days because we have to call the co-pattadars for hearing. It is a mutation case, Lordship. That's why. If Lordship give 30 days, it will some problem to us, Lordship.
But here's a decree.
Decree, Lordship, if there is a co-pattadar for field, we have to do the field verification also, Lordship.
When did this thing happen like this?
By notification, it was there,
To
Lordship.
me, that co-pattadar is there, mutationer. When there is a decree passed by this court, by the civil court,
If there is some, when we give notice to the applicant, co-pattadars, if there's some objection, it cannot be done within time-bound period, Lordship. It take times, Lordship, to hear the parties, Lordship. That's why in the notification, Lordship, if there is no dispute, then it will be done within the time prescribed by the RTPS. Otherwise, Lordship, it takes time, Lordship. It was in the notification. If there is no dispute, then it takes 30 days to complete the process. If there
but a
is
notice period is 30 days.
Lordship. Some 45 days, Lordship.
Notice period is 30 days.
30 days.
Has the section 50 be regulation 50 amended?
No, to office.
Have you amended Assam Land and Revenue Regulation 50? It says 30 days.
30 days. If some objection comes, Lordship, then
Objection is different, but has it been done?
Sure.
Raho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the respondent numbers
2, 3, and 4.
2, 3, and 4. Ms. So-and-so appears for respondent number 1. The grievance of the petitioner herein is that the petitioner has submitted an application seeking mutation pursuant to the judgment and decree passed by the learned court of the civil judge. Dhubri, entitled Appeal number 37 oblique 2011, where the right title and interest of the predecessor in interest of the petitioner.
Defendant, you are defendant.
Yours,
Defendant, our counterclaim was concerned.
where the right title and interest of the predecessor in interest of the petitioner was declared in respect to the land in question. It is seen that this court had issued notice, this court have sought for instructions by the order dated 9/1/2026. And Mr. S.S. Roy appearing on behalf of the respondent number
2, 3, and
2, 3, and 4, respondent number 3, 2, 3, and 4 submitted that the petitioner's application seeking mutation is not available in the RTPS portal of the circulars, which may be due to the non-payment of requisite fee or any uploading issue from the petitioner's side. Taking into account the above, the said instructions placed, this court takes up the instant application for disposal at the motion stage itself. Full stop. The materials on record show that a suit was filed by one Mohammed Syed against one Mohammed Hassan Ali, which was registered and numbered as title suit number 213/2007. In the said suit, Mohammed Hassan Ali, along with the other defendants, filed also a counterclaim claiming right title and interest in respect to the land in question. By the judgment and decree dated 28/2/2011, both the suit as well as the counterclaim were dismissed. Mohammed Hassan Ali, along with another, preferred an appeal against the judgment and decree dated 28/2/2011, passed in title suit number so and so, which was registered and numbered as title appeal number 37/2011. The said appeal was allowed by the learned court of the civil judge, Dhubri, thereby declaring the right title and interest of the appellants in title appeal number 37/2011 in respect to the suit land. Right title and interest as well as possession in respect to the suit land. It is further seen that in pursuance to the said judgment and decree dated 6/8/2015, passed in title appeal number 37/2011, an execution proceedings was initiated, which was registered and numbered as TX number 4/2019. Full stop. The decree accordingly was satisfied upon the handing over of the possession of the decreed land in favor of the appellants of title appeal number so and so. Full stop. The petitioners herein are the legal representatives of Hassan Ali and Abu Sama Sheikh, who were both the appellants. Both appellants, na? Who were both appellants. In title appeal number 37/2011. This aspect is apparent from the next of kin certificate issued by the Circle Officer Dubri on 19/2/2025 and 11/8/2025. The case of the petitioner hearing that in pursuance to the judgment and decree, an application was filed seeking mutation of the land in question. And the said application having not been considered, the petitioner had approached this court. It is pertinent to take note of that the petitioner have not enclosed the application, rather have only enclosed the application acknowledgement date, which is dated 22/2025. At this stage, it is also very pertinent to take note of that while the next of kin certificate of Abu Sama Sheikh is dated 19/2/2025, the next of kin certificate of Hassan Ali is 11/8/2025, which is much after the date of the application acknowledgement. It is also very pertinent to note that a perusal of the said application acknowledgement dated 22/2025 reveals that the application was for mutation after deed registration, which could not have been the reason for the purpose of granting the mutation, inasmuch as the claim of the petitioners basis upon the judgment and decree passed by the learned trial court, by the first appellate court, by the court of the civil judge Dubri in title appeal number so and so, and the subsequent handing over of the possession in pursuance to the title execution case number 1/2019. Considering the above, 4/2019. Considering the above, this court finds that the instructions which have been placed by Mr. S.S. Roy appearing on behalf of the respondent numbers 2 to 4 appears to be correct. Because under such circumstances, this court is not in a position to direct the respondents to consider the application seeking mutation unless and until a proper application is filed along with the documents. So accordingly, this court closes the instant with petition. Accordingly, this court is not inclined to entertain the instant with petition, for which the same stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant with petition shall not preclude the petitioners to submit a fresh application before the respondent number 3, where respondent number 4 seeking mutation on the basis of the judgment and decree dated so and so, passed in title appeal number so and so. And further, the possession being handed over to the petitioner on the basis of the title execution case proceedings being title execution case number 4/2019. Full stop. It is observed that if such application is preferred by providing the necessary details, the same shall be considered by the respondent number 4 as per the provisions, extant provisions of law, and within a period of 3 months from the date from the date such application is submitted along with a certified copy of the present order. It is further observed that in the circumstance, further time is required on the ground that the proceedings, mutation proceedings are contested, the same shall be expeditiously disposed of by following the mandate of law. Good. What is wrong with your internet? Then you should have informed us. Oh, you put your own. Six. What is this?
In this case, the petitioner is the scholarship in the education department program, and he was the grantor, one Azahar. The Azahar get lordship from the SDI Gwalpara, lordship, and 2003, then Azahar is
Why your account has been freezed?
Yes, lordship.
Why?
I was a grantor, lordship, one Azahar.
Huh?
That reason, I was grantor.
Guarantor.
Yes, on that reason, lordship.
Your account has been freezed.
Yes, lordship.
Why?
I was a grantor lordship on Azahar Ali. Azahar Ali got them from SBI Gwalpara.
Guarantor of what? Then a loan of rupees Ria from the State Bank of Ria to one Azahar Ali of Sirikuta. The petitioner stood as a guarantor on behalf of the borrowers when stated the said borrower was a pension holder who died on Iman. Since the date of death of the borrower, no installment was paid and resulted in Iman became irregular and due. Should a demand notice on so-and-so intimating the loan account of the year will get classified. Interest. Now, you are not in a position to operate the account.
Yes, lordship.
Why?
The account is ceased, lordship. By the
How much amount do you have in the account?
And from 8/4/2025, lordship.
And what is your age?
Age is lordship 62 years.
Why there is no age in your affidavit? Huh? So you retired?
Yes, lordship. I retired. Recently retired, lordship.
So you are not getting your pension?
I get pension, but it is lordship, hold lordship account.
You retired as a?
In this month, Lordship.
Hmm?
In this month, I will be retired.
You are
from
not
the
retired.
service.
You are retired.
Yep.
Chalo. Okay. You should notice making it returnable on. Can you take dusty service upon this person concerned? Where is your branch?
SBI, Lordship. SBI Gauhati.
Can you serve it on number 1? Chief General Manager, not.
That's what I,
Huh?
before the filing of the.
No, if you take dusty service, then the matter can be, because you were I can't pass an interim order now. So therefore, the matter requires to be disposed of as early. So therefore, we will take it up on priority.
Yes, Lordship. Of this.
Huh? Issue notice making it returnable on 27/2/2026. The petitioner is directed to take steps upon the respondent numbers 1 to 4 by way of speed post by tomorrow during the course of the day. The petitioner is further granted the liberty to take steps upon the respondent number 1 by way of Dusty, routed to the registry of this court and file an affidavit of service on our behalf on or before the next date. The petitioner shall ensure that the service by way of Dusty is effected upon the respondent number 1 by 18th of February 2026. The case of the petitioner herein is that one Azahar Ali of Sirakuta, Bilasipara, Dhubri, had taken a loan from the State Bank of India of an amount of rupees 2,40,000. The said Azahar Ali expired on 5/5/2023. And thereupon, there has been no servicing of the said of the said loan by making payment of the installments. It is the further case of the petitioner that the said loan account accordingly became an non-performing asset. For non-payment of rupees 86,542 along with accrued interest. The petitioner was issued a notice on 5/5/2025 that the petitioner's account would be freezed, that the petitioner's assets would be attached. In the circumstance, the said amount is not paid. It is a further case of the petitioner that the petitioner also had come to learn that his account has been put on hold on 8/4/2025. The petitioner retired. The petitioner had issued a legal notice on 9/10/2025, but till date, nothing has been done. It is the further case of the petitioner that in the meantime, the petitioner have retired from his service, and on account of his account being freezed, the petitioner is not in a position to even operate the said account to operate the said account. So the respondents herein are directed to apprise this court as to whether such course of action is permissible of freezing the account of the petitioner. Full stop.
Matters regarding ex gratia relief.
What ex gratia?
Lordship, father of the petitioner died on lightning. Using lightning, Lordship.
Sanction has been granted? No.
Lordship. No, Lordship.
Huh?
No, Lordship.
There is no order.
Order, Lordship, page 28. Page 28, you've been communication dated 28/5/25. 28/5/25.
So it seems that you have specialized in this type of litigation? Huh?
It is a natural calamities. So under this scheme.
মোৰ এটা order আছে ন এইটো যে এইবোৰ 2 লাখৰ ক'বাৰ এইবোৰ যে পেমেণ্টৰ order আছে সেই তাতো চাই পেলাই এইটো এলাউ কৰি দিব অকমান এইটো চাই ল'ব এইটো 8/13/2025 সঞ্জয় মেৰি order disposed
Lordship, in this case, petitioner concerned the victimized as a ratio. And because petitioner further applied for compensation as per the government notification and Assam Victim Compensation Scheme 2003.
Mr. Akant, I've seen you after 1 year.
Yes, Lordship.
Huh?
Because my matter particularly regarding civilians 5. My matter particular basically regarding civilians 5 matter like the city. So therefore,
What is your prayer out here?
prayer worship grant compensation because petitioner is a victim as a rare under the scheme of Assam Victim Compensation Scheme 2012. And amendment notification, your worship, if your worship file authorized both to your worship, serial number 3. Yes, sir. Serial number 3. There are two representations, one filed by the victim of the petitioner and one petitioner herself. Victim herself.
আমাদের কেস রেজিস্টার করতে বাকি ছিল না তো তার অ্যাপিয়ার করা হয় তিনবার আমার ডেট দিচ্ছে নতুনবার বলছে না এটুই দিছে তোমাকে তো আয় পাবে
Yes. Mr. Your FIR,
Yes.
where's your FIR?
Hmm.
Charge sheet given?
Yes, person also given.
Page 14.
No, kindly see page 18, charge sheet given. Now the charge sheet is under 365, 376 and 6. Isn't it? Madam,
Yes, your lordship. Yes, yes. Yes,
charge sheet page 18.
yes, your lordship.
So therefore, the reason for which you have rejected,
I have not. The DLSA has rejected it. The DLSA concerned has rejected it. In
whoever
fact,
it is,
yes.
you have produced
No,
this
lordship,
document before
meant
me.
that the original FIR was registered
It's
only
so-
on 365.
Maybe.
Perhaps that is the reason why at
Maybe,
that
but-
particular point of
but,
time.
But this was done on, but thereafter also, this is 8/9/2025,
23, your lordships.
23. Now see, what are these orders? 31/2026, why the petitioner is not appearing?
No, lordship, that is something I'm not very clear about because my instructions were that we have registered a case to, and have asked her to appear. But for some reason, she has not been appearing.
That's why, Mr.
but
Akan, you are
I-
not appearing?
Lordships, I must say that the last one has not been communicated to her. the last order of 31/12, of, yes, 31/12, I think was not communicated to her, if I'm not mistaken. There's some discrepancy on the part of the authorities. They've just telephonically informed me just now, Your Lordships, that although these orders were issued, but for some discrepancy in some administrative exigencies, the actual communication has not gone to the petitioner. So perhaps that is one of the reasons why she's not been able to appear, Your Lordship. So I will have to take responsibility of that. If Your Lordship may kindly give me some more time, I will perhaps get back with fresh instructions next week. And also on the fact as to why DLSA has considered 365 only and has rejected the claim. That is, of course, answerable by the DLSA.
Let's issue notice
Lordships.
and see to it. But why you are not appearing?
Because.
You appear, I'm fixing a date before that, the state legal.
State, yes, Your Lordship.
Because that matter is there. So you go there.
It's better they will appear before the district legal service of Dhubri, because state legal service authority in Gauhati.
Have you not submitted an application before the state legal?
Yes, she
Yes,
has.
Lordship.
Yes, she has.
Why
It
you
is,
not
it is,
appearing?
it is already fixed on
State legal service
27/2.
authority may refer to the district legal service authority.
No. Appear. You have filed an application before that authority.
Because petitioner of the very poor level, Your Lordship.
Huh?
A petitioner belongs from the poor family, Your
So
Lordship.
do it by video conferencing. You
That-
you have a lot of problem. You are very free to do the matter. You go and appear and get hold of that through the video conference.
Lordship.
Over.
That's
Simple.
It is already fixed on 27/2/2026.
We get it done. List is issue notice making it returnable on 6th of March 2026. Mr. N. Gusami accepts notice on behalf of the respondent number 1 and 4. 1, 3, and 4. DLSA, you are appearing?
Yes, he appears. Your
Ah.
Lordship. I'm only.
1,
fixed
3,
file
and
two.
4. But the DLSA secretary is a judicial, is from the judicial. Why it is not being done? Anyways, 1, 3, and 4. Ms. R. Chaudhary, Ms. R.S. Chaudhary appears on behalf of respondent number 2. The grievance of the petitioner herein is that the petitioner while petitioner have not been provided the benefits of the Assam Victim Compensation Scheme 2012 as revised by notification dated 1/2/2019, in spite of the fact that a charge sheet has been filed bearing charge sheet number 564/2023 in connection with Gauripur PS case number 74/2022 under sections 365/376 of the Indian Penal Code, read with section 6 of the POCSO Act.
Hmm.
Good stuff. Ms. Arit Chaudhary, appearing on behalf of the respondent number 2, have placed before this court certain orders being passed by the Member Secretary, Assam State Legal Services Authority. The said instruction, the said order, the compiled orders are kept on collectively kept on record and marked with the letter X. From a perusal of the said, it appears that the petitioner had submitted an application on 23/3/2025 regarding for grant of financial assistance under the Assam Victims Compensation Scheme. A further perusal of the various orders also revealed that the petitioner have not appeared, and the next date is fixed on 27/2/2026. This court inquired with Mr. S.I. Akan, the learned counsel appearing on behalf of the petitioner, as to why the petitioner have not appeared. The learned counsel submits that the petitioner has difficulties on account of financial constraints. Wait.
Sure.
Full stop. Taking into account the above, this court directs the respondent authorities to apprise this court by way of affidavit to be filed on or before so and so. As to why the petitioner is not entitled to the as to why the petitioner have not been granted the benefit of the Assam Victims Compensation Scheme 2012 as revised by notification dated 1/2/2019. This court further also directs the counsel who represents the petitioner in the present proceedings to appear before the Member Secretary, Assam State Legal Services Authority on 27/2/2026. Full stop. On his appearance, the Member Secretary, Assam State Legal Services Authority is also directed to take up the issue as regards the entitlement of the petitioner by using the video conferencing link by way of video conferencing, so that the petitioner can appear from her place of residence at Kokrajhar.
এইমাত্র ধুবড়ি কৈ আছিলা, এতিয়া কোকৰাঝাৰ
An
পৰা।
update be placed before this court on the next day.
Deprivilege. চাই ল'বা, কোকৰাঝাৰ নে ধুবড়ি, এবাৰ
Well, this
Major problems to irregularities in conducting election of Assam High School Teachers Association in Lordship. Election of Lordship. for
the
the post of
government
general
approved,
secretary in Lordship.
held their election for the tenure, and the petitioner is one of the candidates for the post of general secretary of the 45th general election of so High School Teachers Association. For the post of general secretary, there were two candidates, one contesting, one other in the election. He declared the results of the Yes, madam.
Lordship, filed a presentation before the. Chief
What
Election
is you?
Commissioner, Your Lordship.
You and the respondent number 6 contested for a post of General Secretary of Assam High School Teachers Association, isn't it? Now, this is an election of an association. What business does the read code have to do out here?
The association.
So, it's an association.
Lordship,
Go there, civil court.
but charging their Lordship public.
Civil court. Civil court. If election petition is there, go there or civil court. This court would not exercise jurisdiction making everybody a partier. What do you say? Huh? Assam High School Teachers Association election, this court will
approach the civil.
civil court. Withdraw with civil court or dismiss with civil court. Either of 5 minutes. Order is 5 minutes. I give you 2 minutes to choose. Take doctrine of election. Withdraw with liberty to the civil court. Dismissal with liberty to the civil court. Both will take 5 minutes only. Which one? Dismiss with liberty to go to the civil court or withdraw with liberty to go to the civil court? Fantastic. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The present writ petition has been filed alleging anomalies in the election to the post of the General Secretary in the 45th General Elections of the Assam High School Teachers Association. This court inquired with the learned counsel appearing on behalf of the petitioner as to how a writ proceedings can be initiated in respect to an election of an association The learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to approach the appropriate civil court alleging violation, alleging the seeking appropriate declaration for nullifying the election of the respondent number 6 to the post of General Secretary of Assam Teachers Association, School Teachers Association. So taking into account the above, the instant writ petition stands closed on withdrawal. So the withdrawal of the instant writ petition shall not, by the petitioner shall not preclude or prejudice the petitioner to avail remedies before the competent court of civil jurisdiction.
Lordship, this matter pertains to denial of my caste certificate.
What?
Denial of the caste certificate. So far as Lordship comes to annexure number.
Verified and grant the petitioner's claim for issuance of OBC caste certificate strictly in accordance with law. Upon due verification of all materials placed on record. So I should direct them.
Yes, Lordship, in this case, Lordship, there is a pertinent point being involved. Because I came before this honorable court upon the being agreed by the improved communication given by the respondent number 3, that is the District Commissioner Pokash, Lordship.
Where?
Lordship, it comes to case number 67 and annexion number 12.
Page?
67. 67.
64.
Annexion number 12.
Please? 67.
Yes. Annexure 12. Lordship, this is the communication dated 29/11/2025, whereby my certificate was refused on the basis of non-recommendation by the recommended body.
So, what is wrong?
Now, Lordship, here, in my case, Lordship,
There is always a certificate being given by that Sa Janjati.
yes,
Then why you are not getting this Assam Sa Janjati Jatia Sammil.
Because they are the recommending authority. And recommending authority as per one government notification, Lordship. Now the point is, Lordship, they refuse to recommend me for the purpose of applying and getting a certificate for OBC caste, Lordship. Now the basis was, Lordship, that I write my title as Shah. My title as Shah. On that basis, it was being refused. But the documents which I have placed for your Lordship traces back his father to the ancestry, Lordship, where it was written as Rajaram Kahar. He was a tea garden laborer, Lordship, being employed at the Upsi Tea Garden, Lordship. But during the Second World War, Lordship, to subsequent.
Why have you created a problem for yourself having Shah as a title?
Yes. Now, Lordship, my father.
On one hand, you
Yes.
want to take the benefit,
Yes, on that point, I will
and then
address.
you want to be from Gujarat, show yourself that you belong to Gujarat. Shahs are mostly from Gujarat.
On that point, I would like to address Lordship. Now, my ancestry, this is that the adoption of my title as Kahar. Now, as per the central list, Lordship, entry number 2459, Lordship, it recognizes caste as Pohar, K-O-H-O-R, Lordship. Subsequent corrigendum was issued, Lordship, where there was a correction to be Pohar to be read
As Kahar.
As Kahar. And matters were placed before this honorable court for judicial consideration for appointment and selection of the reserved category. I have annexed the order also, Lordship, where Kahar was being considered as an OBC caste, Lordship. Now, my case is, Lordship, that adoption of a title, uses of a surname, Lordship, doesn't dilute my caste identity, Lordship. That is my first point.
That is not the reason also.
Yes, yes. And because my father didn't have a certificate, Lordship, on that basis they rejected. They rejected.
But your father is a Kahar.
Yes,
Your
yes. My
grandfather.
My grandfather.
Your grandfather and your father are both Kahars.
Kahar. My
You have to
father-
prove it.
Yes, through that only I have.
You
placed
don't
my-
need an OBC certificate for that,
Yes.
but you have to prove it on the basis of some certificate before that
Yes.
society
Society,
or
Lordship.
organization.
Yes. Now the problem is, Lordship. Now the ground problem is, Lordship. Since I approached with all my documents on the basis of a representation before the Sammelani, Lordship. Now they refuse to accept, neither verify, neither scrutinize my documents.
Your father's name is also mentioned as Shah.
Shah. But my grandfather, Lordship. My father adopted the title Shah, as Shah. My grandfather is used as Kahar. If Lordship comes to annexion number 1, Lordship, on page 17, Lordship, 18, Lordship, is the Khatiyan issued under the Gwalpara Tenancy Act, Lordship, way back in 1929.
And what is this order passed by Justice B.K. Sharma?
Yes.
For what?
No, Lordship, it is just for a reference which I have placed in the record, because, Lordship, Kahar, Kohar, and Kohar, Lordship, these are phonetic variations, Lordship.
No, all understand.
Yes.
But you are to get it from them. This is the final order. Have you approached this authority?
Yes, I have approached, Lordship.
No, kindly see after page 67, did you approach the authority that kindly give me this certificate? Shah Janajati Jatia Hommilin.
No.
Have you approached them?
Yes, but they did not recommend me, but they,
When did you approach?
before that, only, Lordship, from past 1 year, I have also filed one representation with them, both, Lordship, and the representation is there.
Page 47.
So have they rejected your representation?
They didn't accept. They didn't accept, Lordship. They did not even try to verify or scrutinize whether my.
No, after this order,
Yes, yes.
did you apply to them? My
Before
question.
that, I applied.
After that, this is the second time I'm having the same thing.
Yes.
Earlier there was a contempt application, same thing. After this, did you apply? Then look here, kindly give it to me.
Yes. After that, he has applied, Lordship.
Huh?
Yes, Lordship.
When?
Page 40. Oh, sorry, page 47, Lordship.
Huh?
Page 47.
Okay. Page 46.
612.
Annexure 10, Lordship. The president.
Now, they have not accepted it.
They have not accepted, plus they have refused to verify also lordship on that basis only, because my.
So they have not accepted it.
They have not accepted, and so that I use my name as Shah, lordship. Because first thing is that lordship, I don't have that certificate, lordship, as per the Indian communication lordship. Now, so that I do not have the certificate lordship or use the same title lordship, they have refused. Now, they are purely a recommending authority lordship, recommending body, private, a community-based association lordship.
You have given to whom? President.
Yes,
And why you are making this central committee or district committee? You have given to whom? The central committee.
yes, central committee. Now, district.
And they have not accepted it.
Yes, no, that was before the district committee also, lordship. But they.
This was prior to that. So they have not accepted it.
Yes.
Let's hear from them as to why they have not accepted. Issue notice making it returnable on 9th of March 2026. You can't represent 5 and 6.
No.
Mr. N. Gusami accepts notice on behalf of respondent numbers 1, 2, 3
No, I have for 2, 3 and 4 lots.
for 2, 3, and 4. Social justice,
The standing counsel, RM Das is there, lots.
have you seen him?
No.
Have you seen him?
No.
Okay. Have you served copies
Yes,
upon him?
on the last occasion, matter was listed, lordship, but the direction was given was to serve a copy to the standing council, because.
You have given?
Yes, I have served to my
Okay.
clerk. Because the appropriate instruction will be brought by them, because. it is
Mr.
explicitly
N.
there by
Gusami
the-
appears on behalf of the respondent number 2, 3, and 4. None has appeared on behalf of the Department of Social Justice and Empowerment, though they have a certified copy and earlier copy have also been served upon Mr. R.M. Das, the standing counsel of the said department. Under such circumstances, Mr. N. Gusami, who represents the state respondents and being a government advocate, this court directs him to accept notice on behalf of the respondent number 1. Extra copies of the writ petition be served upon Mr. N. Gusami, the learned counsel, by tomorrow. As regards the respondent number 5 and 6, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the petitioner is also given the liberty to effect service upon the respondent number 5 by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner's grandfather was one Rajaram Kahar,
Yes.
which is a recognized TGCL/ex TGCL. Case of one, this is grandfather so and so, belongs to the Kahar community, which is a recognized TGCL/ex TGCL. And the petitioner's father, instead of adopting the surname Kahar adopted the surname Shah, and the petitioner also have adopted the surname Shah. The petitioner applied for the OBC certificate as belonging to the Kahar community. However, the said application was rejected by the Assistant Commissioner Kokrajhar by an order dated 29/11/2025 by giving liberty to the petitioner to obtain a certificate from the Shah Janojati Jatiya Milani. That is the respondent number 5 and 6. The petitioner thereupon submitted application to the president of the Assam Janjati Jatiya Milani. That is the respondent number 5, as well as also to the president of the district committee of Assam Janjati Jatiya Milani. It is the allegation of the petitioner that the said respondent number 5 and 6 even refused to accept the said applications. And under such circumstances, the petitioner has approached this court. The respondents herein, and more particularly the respondent numbers 5 and 6, are directed to apprise this court by way of instructions as to why the petitioner's application cannot be accepted for consideration. Full stop. This court finds it pertinent to observe that acceptance of an application for being entertained and rejection of an application, and we'll say on the next. Yes.
Before Lordship, their land was acquired by the National Highway Authority, and pursuant to Honorable Court, award was passed by please may kindly see page 78. Operative portion page 80, madam.
Page
80, madam. There it is. Page 80, third para, madam. After hearing the submission, both parties are observed for the acquisition of land, petitioner gazette notifications were made, public notice were published, newspaper so, and but same has been published during the period of lockdown, COVID-19 and pandemic. Therefore, same cannot be treated as wide publication. Thus, the petitioner has no knowledge about the acquisition of Pattal land and could not file objection of the said so award of order. The petitioner have paid the enhancement of compensation of their land claiming zonal valuation so 2021 certified by DC Sunitpo on the basis of which their land acquisition and compensation has been determined is much lower than the actual market value of the land existent by at the time of publication of the Gazette. They have further proceed sale agreement support of their claim and lands near their plots which is adjacent has been sold at the 13 lakh per bigha. The Kala Sunitpur itself reassess the compensation for acquisition of the lands of the petitioner place Samdhara and Samdhara Panigao under Northwest Revenue Cycle by enhancing zonal valuation of land 2021 by increment 20%. This enhancement is applicable only in case of this petitioner may not be treated. After passing of this order, my lord, we have submitted and now we have came to know that they are only enhancing the 20% from the 2020 of the zonal valuation, my lord. 2020 of the junior value 1,15,000 on the basis of that junior valuation, they only given the going to given the 20% matter. So thereby we on inquiry going to came to know that that they are going to process. But in spite of the we are accepted this arbitration award, and they did not do it. And now they did not, so thereby we challenging the land valuation in the 1,15,000, which is much lower, and nearest all are in 7 lakhs and 9 lakhs. This is the problem, madam. Honorable arbitrator has already directed to reassess the zonal value. They are saying
No.
Yes.
Kindly see.
Yes.
The Kalas shall reassess the compensation for acquisition of land of the petitioners under AIA by enhancing the zonal valuation of the land of AIA by increment of 20%. That is the final award.
Yes.
So that is an award. If you want to challenge it, you have to go before the arbitration.
My understanding has my lord to buy my your lordship will go to the Northwest Civil Cycle by enhancing zonal valuation land 2020-21 by increment 20%. They did not enhancing the zonal valuation of the 2020-21. They are
Mr. Bora,
my understanding. Because of that, so thereby I am challenging that my zonal valuation. Because of that is only 1,15,000, whereas nearby in they are given 7 lakhs, and another arbitration award they are given.
so you have to challenge this. You have to challenge it that you see you have produced the sale leads of 13 lakhs.
Right.
That was not considered, but he has only given you enhancement by 20% on the zonal valuation. You have to challenge this before that authority. This court cannot exercise 2026.
My understanding that my
Your understanding is
your
okay,
lordship,
but this
by was written by law.
no.
By enhancing zonal valuation 2020.
We are Mr. Bora, I understand what is written out here, saying that by enhancing the zonal value or valuation of the land by increment of 20%. You mean to say that first he has to enhance, then
Shall reassess your lordship.
shall reassess by how? I understand your submission. Your submission is first he has to reassess by enhancing the zonal valuation and then apply another 20%. My goodness.
So that zonal valuation, I'm challenged before lordship, my lord. Zonal valuation 1,15,000 much lower because of that. Other similar same are my lord.
Can't help it.
If you are not going to challenge this, my lord, they did not do it. Say
You challenge this. This was given in 2025. Go there. Time is there. 90 days, 120 days is there, na? 34.
where we are understanding my lord.
34. I can only permit that this period from when did you file be excluded. I-1/2026 till date be excluded while computing the period of limitation. Then you get the time.
If we are not challenging that zonal value, my lord, that
No, you are not going to challenge. You don't need to challenge the zonal value. You have to challenge on the basis that why on earth the arbitrator looked into the zonal value and said that it has to be an enhancement by 20%. You say that we have given certain other areas of land which is taken as 7 lakhs, sale leads of 13 lakhs. All these things are there, but that has not been considered as per the right to compensation act, which mandates category that 26(1) how it is to be taken, not on the basis of the zonal value. Zonal valuation will only come when? Tell me. When will the zonal valuation will be taken? As per the right to fair compensation?
my lord.
26.
Yes, 26.
Yes.
Determination of market value land by the collector. The collector shall adopt the following criteria in assessing the determining market value of the land, namely, the market value is specified in Indian Stamp Act, so for the registration of sale deed or agreement to sell, as the case may be the area where the land is situated. Or the average sale price for similar type of land situated in the nearest place and nearest density area. Or my lord, consent that amount of compensation as agreed upon the under subsection so and so case of the acquired land private company or public private partnership or project, whichever is higher.
Now kindly see 26.3.
26. Yes, madam. Where the market value under subsection 1 or subsection cannot be determined by the reason that the land is situated in such area where the transaction in land are restricted by under any law or timing in force in that area. Registered sale deed or agreement to sell mentioned clause so and so similar land are not available for the immediately preceding 3 years. The market value has not been specified under the Indian Stamp Act by the appropriate authority.
So zonal valuation cannot be taken unless it comes under 26.3. So therefore, that is your case.
That the arbitration.
So therefore, you do under 34. Because if I issue notice later on, you'll miss your chance. So withdraw with liberty. The heard Mr. N. Bora, the learned counsel appearing on behalf of the petitioner, Mr. Petitioners. Who appears for the revenue? Ms. So-and-so appears on behalf of respondent numbers 1 and 2. Who appears for the district commissioner?
I
You
appear
appear.
along with my friend.
So-and-so appears on behalf of the respondent number 2, 3, 4, and 5. And who appears for National Highway? Ms. So-and-so appears for respondent number 6, 7, and 8. The petitioner herein is aggrieved by the award dated 26/9/2025 by the arbitrator cum secretary to the Government of Assam Revenue and Disaster Management Department, as well as also the fixation of the whereby the award has been passed for enhancement of the zonal valuation of the land of 2020-21 by an increment of 20%. The learned counsel appearing on behalf of the petitioner submitted that in view of the judgment of the Supreme Court in the case of, what is that judgment? So and so, reported in 2022, judgment to Sailugo, 2022-15 SCC 1. The provisions of section 26 to 30 are of the right to fair compensation for so and so are applicable while determining the value of the land in terms with section 3G bracket 7 of the National Highways Act 1956. He submitted that in that view of the matter, the zonal valuation of the land could not at all have been taken into consideration inasmuch as when sale deeds were available, it was the incumbent duty of the learned arbitrator to consider the highest exemplar in terms with section 26(1) of the Act of 2013, rather than applying 26(3) of the Act of 2013, which under no circumstances could have been applicable. This court inquired with the learned counsel appearing on behalf of the petitioner that the petitioner herein has an alternative and efficacious remedy in terms with section 34 of the Arbitration and Conciliation Act 1996. More so, taking into account that in terms with section 3G bracket 5 of the National Highways Act 1956, the award is an award in terms with the said award is an award in terms with the Arbitration and Conciliation Act 1996. The learned counsel submitted that on account of mistaken advice, the petitioner had approached this court, and rather the petitioner would be well advised to approach the proceedings, approach and file an application under section 34 of the Arbitration and Conciliation Act challenging the award dated 26/9/2025, passed in appeal number 18/2022. The learned counsel also submitted that as the petitioner have been bona fidely litigating in the present proceedings, the period from the date the present petition has been pending before this court be excluded while computing the period of limitation. Taking into account the above, this court grants the liberty to the petitioner to withdraw the instant writ petition, with a further liberty to approach the competent court, the court, in terms with section 34 of the Arbitration and Conciliation Act 1996. This court further observes that taking into account that the petitioner had on mistaken advice approached this court, the period from 5/1/2026 till date be excluded while computing the period of limitation for filing the application under section 34 of the Arbitration and Conciliation Act.
The sale deed oblique agreement for sale. Why is there agreement for sale?
You had sale deeds?
The agreement for sale.
Okay, oblique agreement for sale.
Possible matter may be listened tomorrow minus continue with the discussion.
Madam, listen. Unnecessary keeping the matter from all this while doesn't make sense. You are protected by certain orders by the court. You are protected that not to take any action without giving you 15 days notice by providing you opportunity to submit documents. That steps have not been taken. Now the question out here is, you have filed a combined application for issuance of patta. That is Annexure 4. Isn't it? Now, is it permissible as per the Assam Temporarily Settled Area Act to file such an application? If you want a patta, you have to do it as per the provision, individual pattas. Maybe those 3 persons, petition number 1, 2, and 3, being the persons being their predecessor in interest being some A. Chakraborty, they may file together, claiming joint rights. But everybody cannot do it. So therefore, what you do is, you file an application. If it is not considered, come before this court. But not in this manner. Keeping this matter pending does not help you, nor your clients, nor this court is also. Because if I issue notice to them, they will come up with only that thing, that they have to file that application. So therefore, you file an application as per the law. It has to be done electronically also. This is how you do it. Don't write a letter. Heard Miss So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. J. Hendrick appears on behalf of the respondent numbers
2, 3, 4, and
5. 5. Ms. A. So-and-so appears on behalf of the respondent number 1. The grievance of the petitioner for which the instant writ petition has been filed is that the respondent authorities have not considered the application for allotment of settlement of the land in question under Khotian number 1, 32, 45, 46, 49, 50, 51, 52, 55, 58, 59, 61, 62, 64, and 73 of village Bamunpara, part 3, under the Circle Officer Bilaspuripara Revenue Circle in favor of the petitioners. This court inquired with the learned counsel appearing on behalf of the petitioner as to which is the application which have been filed by the petitioners, whose attention was drawn to Annexure 4 to the writ petition. A perusal of the said application reveals that all the 56 petitioners have joined together, 56, 41 petitioners have joined together to file one joint application seeking issuance of individual pattas, allotments oblique settlements. Full stop. Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent, submits that if a person claims allotment oblique settlement on the basis of their rights, the same application has to be filed electronically in the Setu portal, isn't it? Seva Setu portal. And further, the said applications cannot be a joint application claiming the joint application as has been sought to be done in the present by way of Annexure 4 to the writ petition. This court have also perused the provisions of the Assam Temporarily Settled Areas Tenancy Act 1971 and the rules framed therein under. It is the opinion of this court that if the petitioners herein claim that they are entitled to allotment oblique settlement, the petitioners are required to file individual applications claiming such rights. Under such circumstances, this court is therefore not inclined to issue notice in the instant proceedings, is not inclined to entertain the instant writ proceedings on the basis of Annexure 4 of the writ petition. According the writ petition stands dismissed. Liberty, however, is given to the petitioners to apply in the proper manner in the Seva portal, no?
Seva Setu portal.
Seva Setu portal by filing respective applications seeking allotment oblique settlement. It is observed that in the circumstance such application is filed and not considered, the petitioners would be at liberty to approach this court. Yes, what do you want? What is your problem in making such a big petition? What is the case? Tell me.
My senior is coming. This
Huh?
could be admitted.
What is your case? For granting mutation, you make a 56-page petition.
This is here.
Where is the order of 2510? Where is the order of 2510? Ah. Signal period the line. See for the registers. Yes. Oh, what implement application you are referring to? Okay, 2 p.m. 2 p.m. Isn't it required to go to the civil court? Huh?
Yes, Your Lordship.
You're working?
My lord,
You're working?
I am not working.
Then?
Then I am trying for job.
Huh?
I am trying for job, Your Lordship, because he appeared one interview, but that is not yet.
Oh, what job?
My question is, Your Lordship, there are two documents, Your Lordship. One issued by the Jabba and another issued by the birth and death director of registered birth and death. But both the documents, it is contradicted. Your Lordship, my birth certificate, as per my birth certificate, my date of birth is, Your Lordship will find 18/1/1971. As per my birth certificate, page 11, Your Lordship.
So you it was reminded to you only now. You got your admit card done with a 1967 registration. Now you want it at 71. Therefore, I asked you, are you still working? You are now what? 58. Officially 58.
58.
Or no?
58.
No, you can't be.
My
On one hand, in your affidavit, you say you are 58.
As per HSF department. As per HSF.
But isn't it a problem?
Problem is
If you are born in 1967, you are 58 today.
as per HSF.
Okay, you are 58 today.
My
But your case is that actually I'm not born in 67. I am born in 71.
71.
So by filing an affidavit, are you not admitting that you are 58, born in 67, before the court? How do you take care of? Huh?
Yes, ma'am.
How does he take care of that situation?
Yes, ma'am. He has admitted.
Forget about Aadhaar card.
Fine.
I'm not on that. But are you not admitting by filing this petition
Fine.
that you are 58? You should have said that I'm not 58.
Fine.
Wrongly recorded as 58.
Fine.
But
Fine,
your
I did
affidavit
that.
says that I am 58, meaning thereby by on affidavit you accept that you have been born in 1967.
71.
No, kindly see your affidavit filed.
What birth certificate? You know?
Your birth certificate only came into existence in 2025. A person born in 1971 gets a birth certificate in 2025.
Is issued by the legal proper authority or what?
Isn't it the law that a birth certificate has to be issued within a particular period of time? Yes, Mr. P. N. Goswami, you are the Additional Advocate General. Isn't it the law that a birth certificate has to be issued within a particular span of time?
Yes, ma'am.
Here is a birth certificate. He has all admit cards, everything done in 1967. Now he wants a birth. He has got a birth certificate given by the Office of Births and Deaths in the year 2025. He is born in 71. Is it permissible?
They should be made a party, ma'am, in this process.
Huh?
The authority who has issued should be made a party in this proceeding. They should be answerable.
And now he wants a job.
This
I inquired with him, is he working? Normally you see people working out there singing at the time of say, yeah, he says that I am 58 in his affidavit. If he is for 58 on affidavit, then you are 67 born.
So if petition from affidavit. No, affidavit comes.
For birth certificate, you will not.
So birth certificate cannot change everything.
The documents is.
There's only one document.
So one is birth certificate, then it says that it is a contradictory.
Understood.
That
The
is why-
contradictory,
why-
the older certificate, why on earth you were given a birth certificate in the year 2025?
In the HSLG, it is wrongly recorded.
So all this while you were happy till 2025. What steps did you take for change earlier?
Well, birth certificate has to be issued by the authorities on the basis of some document he has furnished, madam. And that too at this stage.
Astrologer. Normally you find astrologer's report, Kunduli, that my date of birth was so and so and so. You are not working. How now you have realized later on that you were born in 2020.
I appeared in interview also, one of for the education department.
What?
That is due to the discrepancies of my date of birth, your lordship. I cannot be selected. That is why my correction of date of birth is required.
Now, you appeared for what? What examination?
For the post of fourth gate, your lord.
Fourth grade. How you are given fourth grade at example 58? Compassionate.
For birth certificate, it is 71. Then my age may be less, your lord.
Then also it is 53. 54.
Like that.
It will be 54.
Never it is. Reason I wanted to correct the date of birth, your lordship. So as per two date of
There,
birth.
Mr. Counsel, there are many petitions.
Sure, sure.
And you got this Aadhaar card when?
Aadhaar card, your lordship will find
When?
on 2019, your lord.
2019. How did you get your Aadhaar card with the date of birth? Let us also know how this ingenious thing. Oh, yes.
Best 12.
Yes, yes.
Aadhaar is proof of identity, not of citizenship or date of birth. And my lord, if he had been working, it would have been different, my lord. For what purpose, my lord, he has procured this?
No, he wants a job now.
That is absolutely impossible, my lord, at this age.
At 54. Which government department will give you? If you have relaxation on the SC, ST also, it cannot go beyond 44.
Yes. He has not disclosed the purpose, my lord.
And also give us this ingenious idea as to how it is possible to change your date of birth after 50 years.
For the employment you will.
If there was another coordinate bench of this court who is not now sitting, this is a case for a CID inquiry. Don't you think so? How on earth the Department of Births and Gifts, after 50 years, gives a certificate that he is born in so and so? You must have got on the basis of the Aadhaar card. How did you get it in the Aadhaar card?
That is
No, you need something.
Fine.
What is your basis? How did you get your name out there in the Aadhaar card with the date of birth of 1971?
why you lordship issue notice about authority
This,
file
no, there are many
because
judgments
I
of
have
the
made the
Supreme Court.
party your lord. I have made the party the authority.
No, sorry.
Let them to reply your lordship.
No.
He has also not disclosed, my lord, for what purpose he needs this change.
He wants a job now.
That is not pleaded, my lord.
That is what he says.
I may be allowed to file an additional affidavit.
No.
Submitting.
This court can't allow these type of petitions to just pass the first threshold. You have to do it now itself. Chalo.
Petition statement.
We dismiss your petition. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Register and births and deaths. Education.
No, I am appearing for respondent number 1 and 2.
1 and 2. And 4? Mr. Gustami, you can appear? Okay. 1, 2, and 4. Gustami. Taking into account the order which this court proposes to pass, this court is not inclined to. This court dispenses with the notice upon the respondent number 3. The petitioner here have approached this court seeking a direction upon the respondents to correct the date of birth of the petitioner as 18/1/1971 in all documents issued by the respondent number 1, inasmuch as the said date of birth was wrongly recorded as 31/12/1967 in the admit card, the mark sheet, and the certificates, etc. This court finds it very pertinent to take note of that in the affidavit so filed by the petitioner himself have stated that he is 58 years old, meaning thereby his date of birth corresponds to the year 1967. Be that as it may, it shocks and surprises this court as to on what basis the department respondent number 4 could have issued a certificate, birth certificate of the petitioner on 27/12/2025, stating that the petitioner's date of birth is 18/1/1971. That is, after more than 50 years. Full stop. Let's go further. The law in that regard is no longer res integra. That unless exceptional circumstances does not merit, comma, the question of permitting change of the date of birth at this late stage is not permissible. Full stop. No circumstances have been placed before this court or an explanation given as to why the petitioner only in the year 2025 realized that his date of birth has been wrongly mentioned and accordingly approached this court. Considering the above, this court does not find any merit in the instant petition for which the petition stands dismissed.
Published.
Yes, what is this?
My land has been acquired for construction of the ring road.
What is it?
No, the Virat compensation has not been properly calculated, my lord. So when I was served with the notice, I write to a collector, my lord, that has to
Land has been acquired
acquired, my lord.
under
Under, my lord, that is National Highway Act, my lord, for construction of that ring road. My lord, we were served notice to do the needful so that we can be given the compensation separately for land and as well as for the Jira. I have a two-story building there on, my lord. I immediately after receipt of the notice, I wrote to the authority concerned that my house has not been properly calculated. Thereafter, my lord, additional deputy commissioner is the competent authority wrote to the PWD building division, my lord, that go and measure that building. That application, that letter is at page 33, annexure 9.
Then
Pursuant to truth, my lord, PWD department writes that circle officer is to arrange a joint inspection. That is at page 33, annexure 10. Well, this notice was issued on 30th of December 2025, but till now nothing has been done, no inspection. In the meantime, my lord, that they have mobilized the machineries and clearing the site. So my anxiety is that, my lord, if my house is demolished at any time, it can be. Then, my lord, my prayer for reassessment or evaluation will become infructuous. So I have come with a limited prayer, my lord, that before demolition, my lord, that is to be as there has been communication by the departmental authority. My house is to be remeasured again, my lord.
you want a remeasurement.
Yes, sir.
Only. That's all. You'll remeasure and then demolish your house.
Yes, my lord. That's my prayer, my lord.
Reassessment will be happen later.
That is
Your only claim is, but your prayer is different. To reevaluate and reassess the Jirat land. No, the prayer cannot be that. The only thing this court can pass an order is because in view of section 3D, the land as well as the building standing thereon has already vested upon the central government. So therefore, you can have no claim over that or to claim or retain on account of non-payment of the compensation. You will be entitled to the compensation. But the only thing is, you need a valuation to be done prior to that.
Yes.
Valuation means an inspection to be done.
yes, my lord. Measurement of the structures. that-
You do one thing, you carry out the measurement and then they demolish.
They will not demolish prior to measurement, my lord.
Therefore, I'm saying that they will carry out the measurement and demolish and do the needful. I won't say demolish, but before initiating any steps for recovery, yeah, you will only measure the building, not the compensation. Will be looked into later so that the basis is there. Means you have the materials. Later on, there might be a case that he may claim more or you may not grant him the benefit also because the existence of the structure is not there. So therefore, you carry out to do whatever you feel like, but before that, you carry out an inspection and prepare a report on that. And in the meantime, you also carry out a valuation report.
I have already, my lord, I have annexed engineer's report from my own side. my lord.
You have already the evidence. So, and this evidence which is there, you will also give it to them.
You have already given, my lord, along with the restitution also. my lord.
You will give it to them.
Sure.
They, on the basis of that, shall again make an inspection and put it down in their records before taking any steps for demolishing the building. We disposed.
Yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B.J. Talukdar appears on behalf of the respondent. Senior counsel assisted by so-and-so appears on behalf of the respondent number 2, 3, 4, and 5. 2, 3, and 4. Miss P.R. Mohanto appears on behalf of the respondent number 1. PWD. Mr. B. Chaudhary appears for the PWD. And you also appear for the government Gaungura, na? 7 also. National Highway Authority of India. I saw Miss RDB.
He was there.
Arbora. We put her name, Arbora.
Government Gamu.
The case of the petitioner herein is, taking into account the dispute herein, this court takes up the instant writ petition for disposal at the motion stage itself. The case of the petitioner herein is that the petitioner is owner of a plot of land at measuring 4 kathas 5 lechas. Out of 2 bighas 3 kathas 2 lechas covered by dark number 38 of KP Pata number 62 at village Thakurguchi under Panbari Moja, Chandrapur Revenue Circle, which the petitioner had purchased by the registered deed bearing deed number 208 dated 5/12/2022. It is the case of the petitioner that the petitioner's name have also been recorded by an order dated 27/3/2024 passed in mutation case number 216/2022-23. The petitioner has also stated in the petition that after the retirement of the petitioner from service in the year 2023, he started construction of a residential house on the said plot of land and have almost constructed the ground floor of the proposed G+2 RCC building. Where is the notification issued?
So the 6 fellow. Page 22.
Huh?
Page 22. Annexure 6. To notice, this is for Zira. Page 24 is for land compensation. The concern is 22.
It is the final case of the petitioner that the plot of land, how much area?
The 4 katha 5 lakh.
The entire plot of land purchased by the petitioner have been acquired by the respondent authorities for the benefit of the respondent number 6, isn't it? Respondent number 6. In terms with the National Highway Act 1956. In that regard, a notice was issued on 7/7/2025 intimating the petitioner for submission of the indemnity bond and other documents so that the compensation which have been determined by the competent authority of land acquisition of an amount of rupees 30,01,696 can be paid to the petitioner. It is the case of the petitioner that the said amount, it is the case of the petitioner that subsequent thereto. Why there are 2 notices?
No, that page 24 is in respect of the land.
And?
Yes, this is for the Zira. In page number 22, my lord, land
It's for the-
amount has not been mentioned.
It is for the Zirat.
Zirat. My lord, let's just,
Then Zirat is there.
Zirat is there, my lord. But
Then
they
what
have-
are you curious?
They have not calculated the house. It's a lump sum Zirat. And these amount.
How do you get the Zirat?
If they measure the
constructed area, my lord.
No, what is Jirat?
Compensation for the land, building and whatever
Huh?
standing on the.
So
actual
building, not land. Jirat is building.
Building,
So the building has been assessed at 30 lakhs.
they have assessed.
Maybe wrong. So under 3G5, you have to go. If you agree with this.
That compensation act, my lord, I have to write an application to the authority
For?
for reassessment, my lord.
So this will be done. See, you can do under 3G1 before the Kala. You can do under 3G1. But if it is not being done, then you have to move under 3G5.
No, they have written to the concerned authority, go and measure. My lord, the PWD authority writes to the circle officer, kindly assess a reassessment, fixing the date and all, my lord. No, that has not been done. Now, my lord, my anxiety is that if it is demolished, my lord, because they have started construction, land clearance.
You have already given, so that will be a part. You already have given the documents that this will be your proof.
My anxiety, if it is not measured before that, my lord, then this will become a futile exercise, my lord.
Why?
I want, my lord, measurement of the house properly. my lord.
So they have measured it and therefore
No,
they have given
they have
30
not
lakhs.
measured. They have not measured. It's a, they have given, that's my stand, my lord. They have given a lump sum compensation and this amount is between 2%, lordship, at page 22. I will get share out of this 30 lakhs.
So
I will not get the
no,
entire.
it may be less. There's no quarrel that if it is less, you have to challenge it.
But my lord, that has to be proportionate to the actual construction area I have, my lord.
Understood, but how can this court decide? And what the relief which you are seeking is cannot be given.
My lord, can you see page number 33, my lord, annex 10. I am on this document basically, my lord. Last page.
Yes.
So this is a letter written to the circle officer by the Kala.
So this they are already given, so good, you already have it.
Only direction, my lord, they will measure it before demolition, my lord.
So then what is the problem?
If they do not
The
measure.
Kala has already passed an order to the circle officer.
The circle officer has not acted on it, my lord. This was in December 25.
So
Now, my lord, they are clearing the site near my house.
So if they don't do it, then they look out. This is what you have already. You have the proof or not?
Yes, my lord, I have given photographs also.
No, you have the proof.
Yes, I have.
No, very good.
And my lord, can you see, my lord, page number 30, annex 8. This is the measurement and estimate I have given already to them.
No case, no case.
Only direction, my lord, they will measure it before demolition, my lord. Thereafter, what happens, my lord?
They say that they don't do. You have already measured it. We'll observe that. If they don't measure it, then your measurement which you have made shall be final.
I'll be happy with that.
No,
My measurement
you
is-
shall measure it because there is already a direction. If they don't measure it, whatever he submits has to be deemed to be.
That direction will also do me. I'm happy with my measurement, my lord. That is at page 30 of the report.
Let me come back at 2.
Yes.
I'll pass that order. It is seen from the records that the 2 notices have been issued to the petitioner. In one notice, both dated 7/7/2025. In one notice bearing number KRA-02/2023 part 1/1128 bracket 21858H bracket close /2449-2519. The Jirat value has been assessed at rupees 30 lakhs 1,696. In the second notice, bearing number so and so number to ek hoy last thought beleg hoy 252449 dash both are same number. Both can't be same number. Both are same numbers.
Both are same number, one number. The serial
Number
there is
so and
different.
so. In the second notice, bearing the same number, the Zirat value has been assessed at rupees 33,47,890.56. It is pertinent to mention that in both the notices, the petitioner and another person, namely Ms. Srimati Ambika Deka, have been mentioned. The grievance of the petitioner herein is, while assessing the Jirat value, the building so constructed by the petitioner have not been properly assessed. Under such circumstances, the petitioner had submitted a representation on 26/8/2025 to the Deputy Commissioner
Also
requesting,
and also to Kalam.
wait, requesting for reassessment of the compensation value of the RCC building affected by land acquisition in connection with the northern bypass of Gauhati from Baihata via Kurua, Chandrapur to Honapur, Gauhati Ring Road of 55.560 kilometers length project. Along with the said representation so submitted on 26/8/2025, the petitioner enclosed the copy of the engineer's report on building evaluation. The copies of the said notices were, the representations were also forwarded to the subdivisional officer Hodor, that is the competent authority for land acquisition in respect to the project, as well as the land acquisition officer. It is the further case of the petitioner that the additional district commissioner Kamkala, that is the competent authority, the additional deputy commissioner Kamkala, Kamrup Metro, Gauhati, had by the communication dated 23/12/2025 asked the respondent number 4 to conduct a joint verification with the concerned PWD department in presence of the petitioner, oblique interested persons, and submit a report in detail for taking follow-up action. It is the case of the petitioner that the said aspect have not been carried out, but steps are being taken to take over the possession, and it is under such circumstances the petitioner has approached this court. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Taking into account that the acquisition is being carried out under the National Highways Act 1956 by virtue of Section 3D of the Act of 1956, upon issuance of the notification, the land vests upon the central government. Under such circumstances, as by operation of law, the land as well as the building of the petitioner standing thereon had already vested upon the central government. This court, it would not be in the interest of justice for this court to stall such taking over of possession. Be that as it may, it is the claim of the petitioner that the Jirat value in respect to the building have not been properly assessed. It is also seen that the competent authority of land acquisition have also asked the respondent number 4 to carry out the joint verification. It would be in the interest of justice that the respondent number 4 carries out the joint verification of the building constructed by the petitioner before taking over of the possession. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The respondent number 4 is directed to carry out a joint verification of the building of the petitioner. And thereupon prepare the necessary inspection report. Number 2. This court observes and directs that in the circumstance, any possession is taken prior to the joint verification carried out, the respondent authorities would be bound by the measurement of the building of the petitioner as per the valuation report so submitted by the respondents, by the petitioner, along with the representation submitted on 26/8/2025. Next. It is further observed, and that observed for the sake of clarity, that in the circumstance prior to the instant order passed, the possession had already been taken. The direction, the observations so made in paragraph number 2 shall not apply. Subclause 2 of the instance, subclause 2 above shall not apply. The petitioner, however, shall be at liberty to seek for enhancement of the compensation and prove the same as per the provisions of section 3G5 of the National Highways Act 1956 on the basis of the evidence available with the petitioner.
Appeared by respondent number 4 and by respondent number 5, engineer of PW.
So that is what I said, na? They will carry out a joint verification and prepare an inspection report.
They have already taken possession by virtue of this 3E. Only thing is that they have not started demolition. That is that what required demolition?
No, no, physical possession. Physical possession has been taken. It was 3 to. Yes, Mr. Purkasta.
I am coming here, my lord. Yeah. We are for issuing a pandama for direction
For what?
to the restaurant number 4. To comply with it or to implement the order of the restaurant number, restaurant number, passed by restaurant number 2. Restaurant number 4 is directed to carry out the order of restaurant number 2. There is a specific order on consideration of, my lord, the relevant material as well as the report submitted by Raj Mondal as well as the, my lord, register, senior register. Petitioner is found to be the purchaser, true owner of the land by right of purchase. And she applied for mediation. Direction was given.
So, Mr. Purkasta, you seem that this court is the complying executing authority of an order passed by the district commissioner. That appears to be. Then why haven't you approached them about with this order? Where?
We approached, we have made a statement, number of occasions we have.
No. Where? Where's your application? Then? Without an application, this court, you want this court to be this. No, why haven't you done it?
But after tomorrow,
Okay. List this matter again.
we posted.
Forget about the clause title. We close it on without seeing the clause title. And you have to make the writ petition shorter. It can't be 53 pages on such a simple aspect. No, Mr. Purkasta, you are troubling Mr. B.J. Talukdar, Mr. J. Hendik, Miss P.R. Mohanto. Everybody is being troubled to read this 53-page petition on a simple issue. Your entire facts are there at page 98.
And the portion, whether court is competent or not, issue a direction. I'm
What?
not saying court is the executive body, court is the authority to issue a direction.
Why should this court issue a direction?
If they fail to, carry out the order, why should I go to civil court and wait for 10 years to get a order, my lord? When my title was not disputed, nobody was there to dispute my title.
So then where have you approached the circle officer to do it? That kindly do it. Mr. A.K. Purkasta seeks an accommodation to file, to bring on record the application filed before the Circle Officer Dispute Revenue Circle seeking compliance to the order dated 25/10/2024. List the matter on Friday.
Friday.
I give you 3 days more.
Can it be next week?
Definitely. Why not? We'll have it next term, next month also. When do you want it? When do you want it? Next month? 16th? 16th.
I'm not about that.
Yes. Who is there? No, 16 month, no, 16 February. Yes, what is this?
This sort of land since 30 to 40 years.
Then?
But the land.
Who is disturbing your possession?
Evict from the plot of land.
Who?
The government.
Why?
As because the eviction drive is going on.
Where?
Dhubri district.
Huh?
Dhubri district. The land records are also in the name of government lordship.
Then?
But how the lands were made government lordship, how it was converted to government lordship, there was no notice served from the predecessors of the lordship.
The land was in your name?
No. In Dakolkar lordship in our name.
Huh?
We have purchased from one Ahad Ali that I have enclosed was the annexure 1, that is the Patiyan.
Civil court? Civil court? Not here. Civil court, get an injunction? Not here. This type of cases, this court is not going to pass an order to the effect.
That lordship, this is the government land lordship.
It's a government land, so suit will appear. You can very well and seek for suspension of the notice under section 80.
Is our purchase land, how it was converted to government land lordship, there was no.
You are not challenging that. Are you challenging that?
Proceeding they have.
Then you are asking for what? What are you asking for? Shall not be issued directing to restore the scheduled land in its original status. Then
Original status is a government.
you are asking for conversion of the scheduled land into government land. How do I know that it is your land?
Land in our name lordship earlier, and since
Where?
30, 40 years we are possessing the same lands. lordship.
Since when it has been government land?
That was not mentioned in the Khatian itself, it shows as government.
These are possessors. Doholkar. Doholkar is different.
Different.
The land is not in your name. It is Doholkar.
Government's name.
That case, no. And you gave the on 2/3/2018 and till date this is going on. You don't have a document also.
Then in our name lordship, during this settlement also they will try to convert it to the.
So where is your application after 2018? You have not done anything. Then no case.
As lordship, how the lands were converted to government land lordship, that may be directed to produce the structure.
Why should I first where it is already a government land you have been shown as possessor? Kindly see your own document.
Lordship, it is Khatian one.
No, possessed land of the state. Kindly see it. Not the of so and possessor. These are possessors. So
They are not a Khatian.
then have you claimed under that Act of Assam Charitable Institution Endowment Act of 1963? Then okay, you are a tenant. No, then
We have information that lordship has large area of that locality were converted to government land lordship due to non-payment of revenue lordship.
madam, you see your name is there. It is a government land since its inception. Page 15 is the inception communication. Then
Khatian itself.
Khatian is always government. Ahom Sarkar. Then why should this court interfere? Okay. Hello. What to do? Dismiss. Dismiss. Because if I give you that direction, that they may evict by giving you 15 days notice and you can produce all the documents and all. If that is being done, understood. So that judgment in the case of what? Salakuddin would apply.
If notice served lordship, then only I can ask for a hearing.
So I'll say that.
But lordship, but then they will immediately serve notice. Lordship, liberty may be granted to go for civil.
Better, no? Ms. Achaudhry, the counsel appearing on behalf of the petitioner submits that taking into account that there are certain disputed questions of facts which are involved, the petitioner would be well advised to approach the competent court of civil jurisdiction. Mr. B.J. Talukdar appears on behalf of the respondent numbers
Lordship, 326, Lordship Sahib.
326 and Ms. P.R. Monto appears on behalf of the respondent number 1 and 2. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberty, however, the withdrawal of the instant writ petition shall not preclude or prejudice the petitioner to avail remedies before the court of civil procedure, before a competent court of civil jurisdiction, if so permissible under law. What is this? If freeze the current account stands in the name and allow the petitioner to operate his current account, bank account at so and so. Okay. Why? What happened to you? Cyber police. All these are your accounts. So your account has been frozen.
47,700 Lordship. If it is a-
Frozen at the instance of the superintendent of police.
40 Lordship.
And why you are making the Reserve Bank a party? Because the bank means what you call mother of all banks in India. There must be some good reason why you are making the Reserve Bank a party. It has been frozen by the Indian bank. Isn't it? Then we are not issuing notice upon respond number 1. Yes. Issue notice upon the respondent number, issue notice returnable on 6th of March 2026. This court is not inclined to issue notice upon the respondent, numbers 2, 3, and 4, returnable on 6th of March 2026. Taking into account the facts involved, this court is not inclined to issue notice upon the respondent number 1. The case of the petitioner herein is that the petitioner has a bank account, has a current bank, has a bank account bearing number 80652799097 in the Machkwa branch of the Indian Bank back at Allahabad Bank. On the basis of a complaint made, the bank account of the petitioner have been frozen and the petitioner is in great difficulties for running his business on account of the freezing of the said bank account. It is under such circumstances the petitioner has approached this court. First, the respondents herein are directed to apprise this court as to under what circumstances the petitioner's account have been frozen. First, by filing an affidavit on or before 2nd of March 2026. Issue notice upon the 1 and 2 steps by registered post, by speed post by tomorrow. In addition to that, steps upon, you are appearing for 4, na?
4 lawsuits.
J. Hendik for 4. As regard 2 and 3, steps by registered speed post by tomorrow. In addition to that, liberty given to effect service upon the respondent number 3 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The dusty service has to be effected on or before 23rd of February 2026. Copy. Yes, what are you asking for? 50 lakhs, why? COVID.
The scheme notification was issued by the state government.
COVID na?
Case 14. COVID-19, yes. The government employee who died in France during the COVID pandemic on COVID control duty, he or she was allowed to utilize the execution to the next of kin or legal years. So the notification at phase 14 and the proposal was supposed to be submitted by the deputy commissioner and it has been submitted.
When did you apply?
My lord,
When did you apply?
I had applied in 2021.
Where? is your application. You have enclosed everything except the application. Huh?
Accepted by the deputy, it is submitted by the deputy.
Where is your application?
That application is not here annexed.
Then how do we know that you applied?
But, my lord, can you find at page 27? Page 27, that proposal is mandated that concerned DC will submit the proposal to the Department of
So this is going on.
Yes.
So they have asked for sanction.
Yes. And this sanction is, my lord,
And the Revenue and Disaster Management Department is not providing the sanction. That is why you are here.
Support provided by the ASDM, that is Assam State Disaster Management Authority.
So because of that you have.
Yes.
Issue notice making it returnable on 2nd of March 2026. The case of the petitioner herein is that husband, late Luftor Rahman, who was working as a UBC. What is UBC?
UBC is unarmed branch construction.
Unarmed branch constable in the Assam police,
Yes.
expired on 18/9/2020 while performing COVID-19 control duty. The said aspect appears to be admitted by the respondents, as is apparent from the communication dated 4/2/2025 issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, wherein the petitioner's husband's name is at serial number 13 and is also seen from the communication issued by the District Commissioner, Dhubri, dated 8/9/2025, whereby sanction was sought for release of the ex gratia grant in favor of the petitioner. It is the case of the petitioner that the respondent in the Revenue and Disaster Management Department has not provided the sanction. And a period of almost 6 years have passed by. And under such circumstances, the petitioner has approached this court. Ms. P.R. Monto, appearing on behalf of the respondent, number 1 and 2, issue notice kori dibodi. You accept notice for 1, 2, 3, na? 3 and 4. 1, 2, 3, 4. 1, 2, 3, 4 are we here? Huh? Extra copies of the who appears on behalf of the respondent numbers 1 to 4 shall apprise this court as to why the necessary sanction has not been accorded, for the financial sanction has not been accorded for the release of the ex gratia payment to the petitioner. Pusto. And provide an update and a footstep. It is further observed that pending the next date, it shall not be a bar on the part of the respondents to provide the necessary financial sanction. so that the amount of ex gratia can be paid to the petitioner.
How much? Some of the cases were disposed of minor by one order. The first case was concerned one in Lasuver. Asked us to apply to the concerned authorities for settlement. Subsequent order passed by other coordinate courts. This was disposed of.
Yes.
And here the petitioners, mainly belonging to minor Gorkha community, their advance, their father's advance was in the X12 Nagaon district of now since 1952, in the Caribbean district minor, affiliate district then, from 1920 onwards. And at least there were some of them have got the documents to show since 1951 they were paying it from the revenue also.
But how do you, were these lands not earlier Gracie PCL not?
They say PGR, but they have not been able to show the notification. They have not been able to show the, your lordship will asking them, they have not been able to show the notification by which it was PGR. Our saying is that it was part of Nagaon district, 1950 and 52. That is the other past.
Earlier lordship passes.
Now what do you want?
Yes, same order will pass on. Since it is passed in all cases. Your lordship earlier orders be different.
This order was passed in the year 2024. We are in 2026. Why are you asking for challenging this impugned notice dated 11/7/2024 now? Where? When is the eviction process started?
The house bond and all property documents were gone down recently. So that's why we have approached this.
Where? Where is your statement? Well, imminent threat?
This one.
Where? The imminent threat for forceful and demolition have caused grave and irreparable injury. Where is the imminent threat?
There is continuous threat, there would be
Huh?
yeah.
Where is the imminent threat? There is no imminent threat.
This one.
Where?
There
Where have
was
you
another-
mentioned? In your pleadings, where have you mentioned about the imminent threat? Friday. Mr. Sharma, Friday. You are not entitled to this type of order also. Same is different. They approached in 2024. We are in 2026. You are sailing a notice dated 11/7/2024. And that too asking imminent threat. Page paragraph 35. See? The imminent threat of forcible eviction and demolition have caused grave and irreparable injury to the imminent threat. How can it be imminent unless you say that after 11/7/2024 there is any steps taken? Where is it? See paragraph 29. It seems to be a repetition of the earlier paragraph and just change the name of those persons. No. What do you say, Mr. Sutia? Mr. Sutia? What do you say? Then it appears to.
Others
Because
come.
up till 29 paragraph, he has the same thing which is there in the earlier petition.
My lord.
Thereafter, he continues to flow
My
with
lord, in
it.
this line, my lord, your lordship's line, the other petitions, my lord, that has been disposed of in the similar line, my lord.
Where is that order? Yeah. But he is not entitled to that, such a good order also.
To approach the, my lord, response number 7, my lord, along with the liberties given to that, my lord. In the similar line of your lordship's order.
Okay, এখন দি dispose করবে। We dispose as per this. Mr. Jayanta Sutia was kind enough. Else I was not inclined. He has shown this order. No, that is different. Those people approached in 2024.
My lord. The supplementary list is also
Here
All
it
the
appears how on earth do I say now? What is the threat? There's no threat. There's not a single whisper
My lord.
about threat which happened now.
In the
You said on the 11-7, unless you write a line, then now these people after 11-7 are going to take action. That single sentence is not
They
there.
have not mentioned anything about the, my lord, incident occurs, discussion with the chief minister, nothing has been mentioned in the petition. But on that basis, my lord, it was earlier disposed of. That there was an incident in Karoni area, people's died. And so that they are lost their documents and so they are approaching now. In earlier cases, those statements were there. But in this petition, those statements were not there.
This is a new petition.
New petition.
এইটো চাই পেলাই দি দিব একেই অৰ্ডাৰ মানুহকেইটাৰ নম্বৰটো বদলাই দিব ইয়াত 195 আছে এইটো আছে
Respondent may be also different, my lord.
চাই পেলাই কৰি ল'ব okay disposed and what happened to the earlier case
And these 2 cases are pending, 5 cases has been disposed of, my lord.
Pending?
This is pending, my lord.
I think we should finish it off.
Yes, my lord, it can be disposed of like that also.
You make a mention and give it to him.
Tomorrow, my lord.
We'll take it up on Friday and finish.
My lord, tomorrow I'll mention it. Tomorrow I'll
This type of
mention it.
matters should not remain.
My lord.
Give a mention memo to him.
Another supplementary list is also there today also.
Is it?
Similar matter, yes.
This matter is not here. No?
Before, not this matter.
This one.
This matter is not there.
You have another supplementary matter.
Under supplementary matter.
Not yours.
Not yours.
এইটো হ'ল Mr. Sutia, you kindly give a mention memo
My lord.
about this case.
My lord.
We'll have it on Friday and
Friday,
finish
my
it off.
lord.
Yes, Mr. HR Ahmed.
Regarding allotment of land, my lord. Petitioner, regarding
Huh?
allotment of land, my lord.
Huh.
Petitioner earlier approached this honorable court along with other petitioners. That order
Allot settled the land measuring 17 bighas in terms with the proposals already made by the extent so and so. How many persons?
Total my lord, space finally see my lord, 53 my lord.
Or to a school?
My lord, police.
Erigul Degrees College. They will be given 17 bighas of land.
17 bighas requirement, as per their notification.
What?
Some notification, my lord. Which may on the page 67.
Then?
When the proposal can see, my lord, page my lord, 53, my lord. 54. Statement showing the allotment proposal under existing settlement notice serial number.
Which one serial number?
22, my lord.
How much land?
70.
Why one is being written by hand?
That is eligible, my lord. There are other documents also there, my lord.
Mr. Hendrik, why at page 54, one is written by hand?
Other documents also there.
My lord, there might be in the, my lord, that college is their degree was not there. I think, my lord, it was earlier. Degree is not the only college was there, lord. I think, my lord, that's why, my lord, they have letter written as them, my lord, that degree.
Subsequent.
No. 22 degree, no, you see 17. 17, one is written by hand.
Oh, lordship, one is written by lordship, my lord. That one similar matter, my learned friend was, my lord, that move in the my lord, morning, the code number 17. That is the one same name, lordship, the secondary school, lordship. So there was, my lord, that time there was, my lord, they claiming for the 7 bighas of land for that school, lordships.
Subsequent documents can see, my lord.
Today in code number 15, lordship.
That is my lord, higher secondary. Secondary school.
In the secondary school, my lord, they are claiming for us 7 bighas of land.
Kindly see, my lord, page 56. Page
Now what do you want?
Page 56, kindly see, my lord. Serial number 27, my lord. Here it is clear, my lord.
Now what do you want?
But after case 57 also there is a proposal, my lord. Thereafter no action taken, my lord.
Huh?
Thereafter no action taken, my lord. Case 57 value.
To give you the settlement.
Yes. There is earlier direction also there, my lord. Case 41. But you know, it's one of the sorry,
What is page 64?
Some petition was already given, my lord.
62, my lord, they are seeking, my lord, NOC from the, my lord, that
64.
62.
It has not been given to you.
Yes. Some of the petitioners earlier approach, my lord, was given me.
So you want to open a degree college? You have not opened.
But case 67 kindly see. This is the office memorandum. And operative portion page 68.
What is this?
Office memorandum of the education, higher education development, and page 68 kindly see. 7-1. Page 68, 7-1.
5 bighas.
10 big.
Shall have its own land measuring 10 bighas in a single plot for the academic year. The requirement of the land may be relaxed to 5 bighas in case of year. Then why are you being given 17 bighas?
Only 7 big also there for playground.
Huh?
Below my tennis.
What?
Body construction, mass. In addition, provision of playground measuring 7 bighas of land is to be made by the sponsoring body.
Where?
The same paragraph.
Serial number?
1-1.
In addition, provision of playground measuring 7 bighas of land is to be made by the sponsoring body. Okay, so therefore you require 17 bighas. And the SLDAC have approved it. They have not.
It was not placed before the, my lord, that SLDC.
Yet to place before the
So then circle officer has not done it. SLDC.
not done it.
So therefore you want the SLDC to do it.
This proposal has been already made.
When was the proposal submitted?
Page number 57, my lord.
Huh?
Page 57, last proposal, my lord.
57.
This is the last proposal. Earlier also there.
16/8/2024. Okay. So your name is here.
Yes.
So it has been sent on 16/8, but they have not taken any steps by the district commissioner.
Yes.
Issue notice making it returnable on 16th of March 2026. It's a higher education. You. Ms. P.R. Mohanto appears on behalf of respondent numbers 1 and 2. Revenue. So and so appears on behalf of respondent number 3 and 4.
I am for respondent number 5, 6, and 7. Lord.
J. Hendrik appears for respondent number 5, 6, and 7. The petitioner herein, who seeks to open a degree college, had approached the respondent authorities for allotment of 17 bighas of land. It extra copies for likhi dibo de. Pusto. As is required in terms with the office memorandum dated 25/2/2019, more particularly clause 7, Roman 1. The proposal of the petitioner have been forwarded by the Assistant Settlement Officer, Nilam Bazar, to the Additional District Commissioner, Land Reforms Branch, on 16th of August 2024. The grievance of the petitioners is that though the respondents have duly considered the other proposals which were sent along with the petitioners, but the petitioner's proposal for allotment of the land have not been considered. And it is under such circumstances the petitioner has approached this court. The respondents are directed to apprise this court as to why the petitioner's proposal have not been accepted. The affidavit be filed, issue notice ketia koriso? 16. Be filed on or before 9th of March 2026.
Petitioners are under the account for that of State Bank of India.
What happened? Your bank?
Bank account is freezed.
Allow them to make transaction in the account and cause. Freezed.
Freezed.
Why?
There is lien amount of rupees 2,000. Lordship will kindly see page 24. It's a statement of the bank.
Your account number is so and so. The authority of the earth freeze the account without giving any prior notice.
This 24 is a statement of the bank. Lien amount is 2,000.
Huh?
The lien amount is 2,000 and that 2,000 rupees is hold, Lordship. But I don't know how this 2,000 was hold and how the amount came.
So you have a amount of rupees around 25 lakhs in your bank.
There is more than 25 lakh, but for lien amount of rupees 2,000, my whole account is in freeze, Lordship.
Okay.
And I am now unable to operate the.
When was it freezed?
From the month of December, Lordship, December past.
Yeah. Issue notice making it returnable. On 27th of February 2026, steps be taken by way of speed post upon the respondents by tomorrow. In addition to that, the petitioner is given the liberty to take steps upon your branches at Simaluguri.
Yes, Lordship.
Upon the respondent number 4 by way of respondent number 2 and 4 by way of Dusty routed to the registry of this court and file an affidavit of service on or before the next date. The said service be effected by way of Dusty on or before 23rd 3rd of February, no, sorry, 18th of February 2026. The grievance of the petitioner herein is that the petitioner has a bank account bearing current account number 44633983652 with the State Bank of India Simalaguri or Simalguri? Simlaguri. 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 Porpeta. Without any notice or reasons, the petitioner's bank account have been frozen. Though the petitioner and resultantly, but the petitioner, who is the MSME enterprise. You're an MSME, na?
Manas Enterprise. Manas Enterprise.
Who are you?
I'm the proprietor of Manas Enterprise.
Understood. Petitioner whose proprietorship firm is a MSME is not in a position to efficiently carry out its business. The respondents herein are directed to apprise this court under what circumstances the petitioner's account have been frozen by filing an affidavit on or before 25th of February 2026.
In this case, I have an instruction to appear on behalf of respondent number 1, my lord. If lordship permits can be taken up day after tomorrow, I would have the copy of my petition, my lord.
What?
I have the instructions to appear on behalf of respondent number 1, my lord.
Who is respondent number 1?
In whossoever award is there, my lord.
What is the matter he is asking for? There is some order passed.
Yes, my lord.
Order has been passed. Yes, insurance.
Then?
Well, we are just challenging the part, well, the GST component, which, well, the materials which were consigned were lost in the transit. So, well, we are just challenging that GST components still, well, existing. The input takes credit, well, we are already aware. So that cannot be, well, indemnified by the insurance. Only to that extent it should be. The respondent booked 3 consignments. And
where is that order?
My lord. Page 20, my lord, starts at page 20.
Page?
20. Sorry, 28, 27.
How much? 10 lakhs.
My lord, the award is conditional award has been awarded, my lord, at page 32. My lord, paragraph 8. 7. The complainant shall submit with the respondent insurer an affidavit sworn before a notary declaring that the tax amount mentioned in the subject invoices is paid to the government and the same has not been adjusted against subsequent tax payment or applied as refund, or that they will not claim any such refund in future. Or if they provide these 2 documents to the insurance company, then the award is be paid as 24,18,000. And if they fail to provide this affidavit, then, my lord, the award is to be paid as 10 lakh.
So they have provided the document.
They have given the affidavit. Our contention, my lord, all along was that, my lord, these GST components, my lord, exist in the, my lord, GST chain, my lord. Until unless the respondent issues a credit note to the buyer, or, my lord, he seeks a reversal as provided under the section 34 of the GST Act. My lord, this liability exists, my lord, the availing that benefit, it stands in the GST chain. That was our contention.
So this is only for tax invoices?
Yes, ma'am. Tax invoice.
And why if he provides the document, fails to provide, then why is it 10 lakhs?
10 lakhs is the, my lord, actual loss, my lord, which we also agree to indemnify.
You paid the 10 lakhs.
No, man.
Why?
We are ready to pay that. We are ready to pay that.
Okay. Pay that 10 lakhs.
Yes. In fact, my lord,
You
it's a
pay
lot.
the remaining.
My lord.
First get your money and then fight.
My lord.
Huh?
My lord.
Issue notice making it returnable on 18th of March 2026. Are you making the insurance ombudsman the party? Why?
I think that pertain team.
Okay. The petitioner herein have will you strike off? Mister, will strike out insurance ombudsman. Issue notice upon the respondent number 1, returnable on 18th of March 2026. Mr. R.S. Mishra appears on behalf of the respondent number 1 and accepts notice extra copies of the petition be furnished to him during the course of the day. Mr. R.K. Batra, appearing on behalf of the petitioner, submits that the respondent number 2, name of the respondent number 2 may be struck off, taking into account that the respondent number 2 exercised judicial functions. Taking into account the above, the name of the respondent number 2 is struck off. The issue involved in the instant proceedings pertains to the legality and validity of the Insurance Ombudsman Award number IO/ZU/A/ZI/0092/2025-26, dated 2011-2025, passed in complaint case number GUW-G-049-2526-0067. The limited case of the petitioner herein is that the impugned award would amount to unjust enrichment upon the respondents, taking into account Section 34 of the Central GST Act 2017. Inasmuch as the petitioner cannot get, having already availed the input tax credit, respondent number one having already availed the input tax credit, the respondent number 1 cannot be granted the benefit of the tax invoices. Mr. R.K. Butler, counsel appearing on behalf of the petitioner, further submitted that the respondents herein, the petitioner herein does not have any objection in making payment of the amount of rupees 10,90,059 as awarded by the impugned award, and the remaining amount be kept in abeyance. This court have also heard the learned counsel appearing on behalf of the respondent number 1. And a question duly arises as to whether the respondent number 1 have taken benefit of the input tax credit in respect to the present proceeding, in respect to the claim so made. This aspect can be seen from the pleadings as well as the documents so enclosed. Accordingly, the respondent number 1 is directed to bring on record its stand by filing the affidavits on or before 11th of March 2026. Liberty given to the petitioner to file a reply thereagainst on or before the next date. Pusto. This court have also duly taken note of the submissions on the interim prayer. And taking into account the materials on record, it is the opinion of this court that the petitioner is entitled to certain interim directions till the next date. Accordingly, Pusto. Subject to interim till the next date, subject to making payment of the amount of rupees 10,90,059 to the respondent number 1 on or before 9th of March 2026. The remaining amount as have been awarded by the insurance ombudsman in the award dated 2011-2025 shall remain state.
Much obliged.
Yes, yes.
What is this, Mr. Sekia?
Case lordship amendment in petition I have filed lordship.
Not be
And
issued in
there
favor
is
of-
not follow court order is taken lordship 24/9/2025 lordship. When permitted as lordship to amend the late petition law. Accordingly, I has been permitted lordship and we have filed an IA lordship 73948/25. Now lordship the present amended late petition has been filed. Willing sought for direction lordship to the ombudsman to dispose of our simple representation lordship.
It's pending.
Yes, pending lordship. Annexa H and H1 lordship, page number 34 and 34.
Have they received it or not?
It's initially lordship, they have refused to receive lordship. Subsequently, they advise us to upload it to their official website.
Why they have refused to receive?
Lordship, they simply stated that there is a procedure to upload our application through website. Accordingly, we have uploaded the same through official website as well as we have sent it through restart procedure.
Then
Lordship, same has been, no any effective order has been passed by the ombudsman.
no, have they registered it?
Lordship, not registered.
No, they have to register as a complaint, na?
Yes.
Where is the complaint?
Annexa H, lordship. Page number 34. Lordship.
What is the case here?
Lordship, our case is that lordship, my husband died in a road accident, lordship, but he is working lordship as a manager lordship in Bajaj Alliance Corporation Life Insurance. Lordship. Accordingly, he is entitled to.
In a road accident.
When died in a road accident.
Then
Then lordship, during his employment lordship working as a manager lordship in the Bajaj Alliance Life Insurance lordship, he has obtained one term insurance lordship. Cover policy is there in the appointment letter of offer letter lordship annexary page number 14 lordship. And accordingly he entitled to such certain relief lordship, but same was not granted to me lordship. Being I am legal here, I am a wife of the victim lordship.
and who is 7? Who is respondent number 7?
Respondent number 7, private respondent.
Obviously.
My mother-in-law.
So you want to deprive her?
Lordship?
You want to deprive her?
No, lordship. But
They are going to give it to the respondent number 7.
my mother-in-law name has been inclusion, but prior to my marriage, lordship,
Her mother-in-law
he was appointed. Accordingly, my name was not mentioned as a nominee.
Day after. So your fight is with your mother-in-law.
Not only mother, lordship, the mother is entitled to get at least 50% share. I admitted fact, lordship. I have approached before the authority and informed the authority that if required.
But
maybe
your
even
main
promotional
allegation
share.
is against your mother-in-law.
I'm not against the mother.
Have you read the petition properly? You are alleging your mother-in-law committed fraud.
Yes, that was what this certificate my mother-in-law has obtained from the Lakhimpur district. I intimated that. That is why, but my husband died in a road accident at Jalukbari. At date one, death certificate has been issued by the GMC. But subsequent state, without my knowledge, my mother-in-law has obtained one death certificate from the now at Lakhimpur. That is why, only because of that, at the time of opening his account.
But Gaon Panchayat, the death certificate would have any value?
No.
Taking into account the right of the what you call the registration of death, or has to be done under the registration of death, Births and Deaths Act.
No, lordship, but one death certificate has already been issued to me by the GMCS authority, the authority of Gauhati Medical College. But subsequent it says without my.
Have you submitted that aspect to the Bajaj Alliance or not?
Yes, I have already submitted before the Bajaj Alliance.
So is there any
stating that
move to give it to the insurance ombudsman? Why are you moving the insurance ombudsman?
Initially, Bajaj Alliance has refused to provide me any information as because saying that your name is not inclusion as a nominee. So we are not inclined to provide any information, although your husband is dead, died in a road accident, but your name is not inclusion as a nominee.
Who is the nominee?
Nominee, my mother-in-law name has been inclusion as a nominee.
But she will only accept it as a nominee, is only a trustee. There are many Supreme Court judgments.
My mother-in-law entitled to get at least 50% share. I have admitted fact. But your case is that
Okay,
wife
understood.
of the victim.
Okay,
So
issue notice making it returnable on 18th of March 2026. Who is appearing for all these? Union? Anybody? You. Mr. S.S. Roy accepts notice on behalf of respondent numbers 1 and 2. Employee State Insurance Corporation.
State Council.
Why are you making the SIC a party? Your concern is as regards a particular policy.
Yes.
You don't have anything else. Why are you making all these people a party? Why are you not making the insurance regulatory authority as a party? You are making the finance department as well.
Yes, I see.
What?
Apart from yes, I see other respondent will be.
No, 1 and 2, I don't think we should issue notice. Issue notice upon. No. Not
every financial authority.
No,
that is
nothing
why
doing.
Dr. Bhai implemented.
Nothing doing. You have to make the insurance regulatory authority a party. It's not that. Issue notice upon the respondent numbers 3, 4, 5, 6, and 7. Returnable on 18th of March 2026. This court is not inclined to issue notice upon the respondent number 1 and 2. The petitioner is directed to take steps upon the respondent numbers 3 to 7 by way of speed post by tomorrow. In addition to that, liberty given to the petitioner to effect service upon the respondent number 4, 5, and 7 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. the service be effected upon by way of the stay on or before 9th of March 2026. The case of the petitioner herein is that the petitioner's husband expired
arising out of Jalapa
on account of an accident on 25/3/2025 at around 9 p.m. at Jalukbari near railway overbridge. The petitioner accordingly was entitled to what you are entitled to for what?
entitled to
Huh?
get the accidental benefit lordship, term insurance arising out of the.
Where is the term insurance?
Lordship, annexure A, page number 14, lordship. That is the offer letter.
So you are
Dividend
not
page number 16.
you are not on this term letter, but you are entitled to the service benefits and the pensionary benefits.
No, that is the private lordship. That is the only term insurance.
Where?
Lordship, in page number 16, lordship.
You have got this amount, compensation breakup.
I have not received it. That is good term.
So this is the benefit you are asking for, page 15.
Page number 16, lord.
What is this page number 15? Have you got this amount?
No, not lord.
What?
I have not received. But I have.
It is the case of the petitioner that the petitioner is entitled to. Entitled to what?
In purview of the offer letter, lordship mentioned as the group term life insurance, you will be covered by a life insurance cover for a sum issued as per company policy. This cover remain
Okay,
only
he
as
is entitled to the benefit of the group term life insurance on account of the death of her husband. As was the conditions of service of the offer letter issued to her husband dated 13/2/2024. It is the further case of the petitioner that the respondent number 7, who is the mother-in-law of the petitioner, had applied for a death certificate from the Lakhimpur District Administration and approached the authorities of the Bajaj Alliance for release of the benefits. The petitioner have also obtained a death certificate of her husband from the Register of Births and Deaths at Kamrup, and also claimed benefits. The non-granting of the said benefits have constrained the petitioner to approach the insurance ombudsman. It is the further case of the petitioner that the insurance ombudsman have also not accepted her complaint. And it is under such circumstances the petitioner has approached this court. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 13th of March 2026.
This is regarding termination of the service matter for the last occasion of my learned side and which within the notice my.
You are challenging what?
Reading page 49 of the petition by this termination order.
The termination order.
Yes, madam. On the basis of an inquiry where my lord inquiry is made, the petitioner has not been served any copy despite of the repeated request, and even in the reply he has submitted before the authority, at least to know what is the inquiry and to give an effective reply, my lord, that has not been given. Last month. What shoppers notice, my lord?
You have not furnished the inquiry report.
No, this is not a termination. Firstly, this is compulsory retirement.
No,
This penalty order.
Isn't it a punishment?
It's a punishment of compulsory subject. I'm just correcting my learned brother, my lord. It's a punishment of compulsory retirement from service.
This is done under 7.5.
Yes.
So if it is done under 7.5, then obviously he has a right. If you are doing it without an inquiry, it's a different thing. But here you are having an inquiry.
No, inquiry report, my lord, perhaps it has been
No, you have initiated an inquiry proceeding.
I'll get the instruction, my lord. So far as inquiry report has been served upon the petitioner or not, I'll get the instruction. But apart from that, my lord, I'd like to point out two things. Firstly, the appeal is pending. Departmental appeal that he has submitted, that is pending, and he has submitted the appeal before the district and session judge against the order of the district and session judge. This should have been before the secretary of the judicial department.
Let it be. Kindly see page 45.
Yes, madam. Thus charge against the has been proved, and after going through the service of below mentioned conduct.
Wouldn't the judgment of the Supreme Court, Constitution Bench Supreme Court judgment ECI versus N. Karunakan would not apply?
My lord, inquiry report furnished or not, that instruction I'll get, my lord. Today I don't have that instruction.
Thursday?
Next Thursday?
Coming Thursday? Today Monday.
After that.
Only you have to obtain inquiry.
Fine.
So then we set aside this and ask you to issue a fresh shock cause notice by giving him the inquiry report and proceed.
Fine, my lord. Fine.
It's only that only.
Yes.
Unnecessary keeping all these things doesn't appear.
Yes, my lord.
Only that instruction.
Yes.
Issue notice making it returnable on, because these type of matters has to be finished as soon as possible.
True, my lord.
Issue
The
notice.
allegations are also very serious.
No, whatever may be, do whatever you feel like.
I understand, my lord.
But you cannot terminate like the compulsory.
The inquiry report has to be furnished, my lord. That's the mandate of law.
Issue notice making it returnable on 12th of February 2026. Mr. S. Roy accepts notice on behalf of the respondent number 1. Mr. H.K. Das accepts notice on behalf of the respondent number 2 and 3. Extra copies of the writ petition be furnished during the course of the day. The grievance of the petitioner herein is that a departmental proceedings being DP number 02/2024 have been initiated against the petitioner. Full stop. Pursuant to the departmental proceedings being initiated, the petitioner had submitted the written the statement of defense. An inquiry was conducted. And in the inquiry, the charges framed against the petitioner were stated to have been proved. The petitioner was issued a show cause notice on 12/3/2025. asking the petitioner to show cause within 7 days as to why he should not be imposed penalties in respect to the said TP proceeding. The petitioner sought for the inquiry report. But the same was not furnished. It is the case of the petitioner that without furnishing the said show cause notice, the petitioner was compulsorily retired by imposing the major penalty of compulsory retirement in terms with Rule 7, Roman 5 of the Assam Services Discipline and Appeal Rules 1964 by an order dated 25/3/2025. Being aggrieved, the petitioner has approached this court alleging violation of the principles of natural justice as well as also the violation of Article 311(2) of the Constitution of India. The counsel appearing on behalf of the petitioner also submitted that it is no longer res intriga, that the inquiry report has to be furnished. And in that regard, have referred to the judgment of the Supreme Court in the case of ECI versus N. Karunakaran, reported in 1993, 3 SCC page, 4 SCC page,
727.
727.
B Karunakaran. B Karunakaran.
Mr. So-and-so shall apprise this court, now taking into account the settled principles of law. The only instruction which is required is as to whether the imposition of the punishment upon the petitioner by the order dated 25/3/2025 was preceded by furnishing the inquiry report to the petitioner. List accordingly.
Much obliged.
No, or non-consideration of representation of seeking express payment.
How did he die?
He was like accidental throwing not.
Huh?
Accidental throwing not.
Accidental. Then?
The public pond not. In a public pond.
When did the accident happen?
It was happened not.
Accidental drowning on so-and-so at so-and-so. Incident was registered as so-and-so. The date of year death certificate was issued. Guidelines notified and adopted the government of Assam and expressia of so-and-so. I am the legal next of year which is certified. Who are you? Who are you? Wife. Despite that, I humbly submit. Okay. We dispose it of. Directing to consider. And upon verification, if it is found, he will get it. Our order, no?
Even the Lordship Mala that he applied that representation before the Mala that Dibugar Lordship.
Where should you shoot?
He is as part of that petition Lordship Mala, he is from the Shivsagar.
But accident was happening under the jurisdiction of Dibrigarh district.
Huh?
It's the border area. Accident happened in the, under the jurisdiction of Dibrigarh. That's why I have submitted representation to the DC.
You do one thing. Submit a representation. This is under the revenue and disaster, no? before the principal secretary.
Lordship.
Well, order as a principal secretary, shall consider and so on. So that is where he makes a submission that look here, we do have to verify as to all these things will be correct.
The additional chief secretary, revenue.
Every additional chief secretary.
You are apply.
Made page law.
This morning, my dad friend made an appearance because we are not implemented on the basis of complaint made by us, my lord. This order has passed, my.
Let them be party, I have no objection, my lord. Let me place my case.
Okay, you place your case. You place your case.
Yes, yes.
We'll consider whether he.
Date of birth is first of January 2013, sorry, I'm sorry. My date of birth is 1/1/1992. But in the records maintained by the Board of Secondary Education, it has been recorded as 1/7/92. So, my lord, if your lordship should kindly come to my birth certificate at page 22.
23.
22, 23 is the original, yes. 23, my lord. And similar date of birth, most important is, my lord, date of registration is 8/1/92. But this was issued on 23/2002. Based on this, my lord, I applied for correction of my date of birth. I applied on, my lord, at page 29. After paying the requisite fee and all. Then, my lord, at page number 30. And 31, it was corrected.
Then?
Now what had happened, my lord? Then without notice, without anything, my lord, on 20th November 2025, an order has been passed by the SEBA, my lord, whereby the earlier correction has been cancelled. Now the reason they cite is that if your lordship should kindly come to page 32.
Page?
32, my lord. That's the impute order. May I have your lordship's kind attention to the third subpara. And whereas on 12/11/25, a letter from Additional District Commissioner South Salmara Mankasar was received by so-and-so mentioning that Sri Rasid Akanda, that is the petitioner, bearing roll number so-and-so, on 7/11/25 submitted admit card and pass certificate to the 4 District Commissioner South Salmara Mankasar regarding a matter related to child marriage related case of Panchayat election, indicating his date of birth as 1/1/92. It was also further stated that in verification report of his office, the date of birth of Rasid Akanda was mentioned as 1/7/92. The ADC further requested the verification of the admit card and pass certificate of the said candidate. And whereas a reply letter was sent to the Additional Deputy Commissioner South Salmara Mankasar wife dated, stating that date of birth correction from 1/7/92 to 1/1/92 in respect of Rasid Akan was allowed on 22/9/25 on the basis of copies of the birth certificate, voter ID, PAN card, Aadhaar card, driving license, ME school, transfer living certificate, and court affidavit. The ADC South Salmara Mankasar was also requested to verify the genuineness of the copy of the birth certificate of the candidate and, if possible, of other documents submitted to this office at the time of correction by the candidate. And whereas in response to the aforesaid reply dated so-and-so, a letter was received from the Additional District Commissioner South Salmara, wife dated 18/11/25, stating as follows. The birth certificate record maintained by the Office of the Subdivisional Magistrate and HO in charge cum register of birth and death so-and-so for Rasid Khan bearing registration number 104 has unfortunately been destroyed
you to fire as officially communicated by the concerned authority. But due to which the authority are unable to verify the authenticity of the birth registration certificate. Moreover, there are instances of issuing fake certificate in the name of said institution. It is worth mentioning that a person was arrested in connection with the case number so and so. Although the birth certificate was issued in the year 2002, Rasid Akanda appeared in HSLC examination in the year 2009, and there was no earlier attempt of record correction made until a child marriage case was reported. Now, my lord, in the
Okay,
year
when was the case reported?
Which one, my lord?
Case of child marriage was reported when?
2009.
Huh?
No.
Sorry.
Child marriage came only recently.
Sorry, sir, 9 was the yes, but it was never reported by anybody. Now, my lord, I'll give the actual facts, my lord. Now, which I have mentioned. Actually, my lord, they want to say that when I contracted the marriage, I was not of the marriageable age. That is basically is the case. I'll demonstrate, my lord, why that is wrong. My lord, my wife's date of birth is 31/12/94. My marriage was solemnized on 1/1/2013. So petitioner was 21 years age when marriage was solemnized.
Wife is 31
12/94.
and marriage was solemnized on
1/1/2013. Milord, I was 21 years of age when my marriage was solemnized, and even my wife was above 18 years of age on 1/1/2013.
Then?
And under the Act, provisions of the Act, please come to para 9, Milord, page 12. Milord, para 9 and 10 at page 11 and 12. That so far as the allegation of child marriage is concerned, the petitioner begs to state that date of birth of the wife of the petitioner is 31/12/94. Marriage of the petitioner was solemnized on 1/1/2013. The date of birth of the petitioner is 1/1/92. Therefore, there is no question of child marriage at all in the present case. Section 9 of the Prohibition of the Child Marriage Act is quoted herein below. Punishment for male adult marrying a child. Whoever being a male adult above 18 years of age contracts a child marriage shall be punishable with rigorous imprisonment, which may extend to 2 years or a fine, which may extend to 1 lakh or in both.
But it is 18 then also, if it is taken 1/7/92 also.
Then also nothing happens.
Nothing happened. Then why is this?
I don't know, Milord. Because kindly see, because the complainant is before the your lordship. Even if it is
Complainant has
1/7/92.
no business of.
And my lord, lordship has already dealt with this issue, my lord. Lordship has already rendered the judgment in WP AB, my lord, 734 of 23. Can I pass on it? In a bail matter, lordship has the occasion to deal with.
Me?
No, my lord, has the relevance in it.
This is another person.
Kindly come to the page 2, Milord, the first subpara. It is the case of the applicant that the applicant married Jennifer Wahid Chaudhary on 20th of July 22. At the time of marriage, the applicant was 20 years, 9 days, and his wife was 19 years and 1 month, 10 days. Taking into account the provisions of the Prohibition of Child Marriage Act and Protection of the Child from Sexual Offence Act, the case of the applicant is that the wife of the applicant was of marriageable age. However, the applicant having not completed 21 years was not of marriageable age. Learned Counsel for the applicant has drawn the attention to the judgment of the Supreme Court in case of Hardeep Singh in so and so, wherein Supreme Court at paragraph 3.8 had observed that section 9 of the Prohibition of the Child Marriage Act has to be viewed in the backdrop.
It's okay. Now, this was preceded by any notice or not?
Nothing, Miller. Nothing. All of a sudden, Miller.
And tell me, who are you?
No, I have something to say, madam.
Huh?
This whole case is, madam, as per Prohibition Act, madam. Child means either male or female. Male is to be 21 years, female 18 years.
Now, who are you?
I am the person who filed the complaint on the basis of which the inquiry was made.
Now, how are you connected with the wife and the husband?
I contest along with him, madam. I contest the election.
Election?
Panchayat election, yes.
Then?
Ward member, he won the election and I lost the election. I am second position, madam.
Then?
After the election is over, then we came to know that he is underage, that husband of the elected candidate.
Then?
Then I filed a complaint before the authority. Then came to the.
So, without your complaint being mentioned in that order, and they have initiated.
Now come to know that we filed a complaint before the legal service authority. They came before this honorable court. Ultimately, this honorable court found that some procedural lapse was there. They have cancelled this set aside the order, giving a chance to give liberty to file another matter that to go as they like. Accordingly, again proceeding was drawn. Hearing was also given, my lord. Notice was given. Then they have not appeared.
So your question is that if he is a minor.
Yes.
And have married.
Yes. Either of the party, my lord.
Had married.
Yes.
Then in that regard, he is a criminal.
No, not criminal, my lord. Parliamentary says disqualified, my lord.
No, he is disqualified.
Disqualified.
Because of his criminal antecedents.
No, not criminal, because child marriage.
Violation of child marriage.
Oh, nothing.
So, no, child marriage by him.
Yes, but you'll kindly see what X child means. Meaning of the child as per this act, my lord. Meaning of child is that means a person who, if a male, has not completed 21 years of age. If female, not completed 18 years of age. He is a male, husband. So either of the two, if one of them is minor, it is disqualified. As per Panchayat Act, my lord, who either by himself or by his spouse has violated the age of marriage, is disqualified. As per Act.
But anyways, we are going to stay this issue notice.
No, your lordship kindly hear me, my lord.
No.
No, what is, my lord, your lordship?
We'll hear you when you file your application.
I made an application for imprisonment, my lord. I am the necessary party. Let it come day after tomorrow. I'll file tomorrow, my affidavit. Let it come day after tomorrow, my lord. I'll file my tomorrow, my lord.
In your application, have you stated that you have filed an complaint?
Yes.
And on the basis of the complaint, the proceedings have been taken? Have you mentioned?
Yes.
But there are two requirements for you to be a party. That you had filed a complaint.
Yes.
And on the basis of your complaint,
yes,
the proceedings was taken by that authority.
Yes.
Have you mentioned
disqualified?
That?
On the basis of this, it disqualified. It is not before your lordship, my lord.
No, I'm asking you. Whether have you mentioned that you filed an application before the Assam Seba board?
Yes.
One.
Yes.
And on the basis of your proceedings or your complaint,
I did.
the order dated 2011-2025 was passed. Have you mentioned that?
Your lordship will find, received one candidate, Rashid Khan, my your kind is imprint order, my lord. He filed an application. In the meantime, board have corrected. Thereafter, I filed application that it is not my lord correct. Again, inquiry was made. Thereafter, this again it was cancelled.
So, at your instance,
yes,
the inquiry was made and the order was passed.
Yes.
You have mentioned that in your application?
Which application, my lord?
Yes,
it is. Kindly see I have submitted in my implement. It is not here. No, it is not. It has not come, my lord. We are having it. So that's why I'm saying, my lord. That
okay, Mr. Chaudhary, we'll have it on next Friday.
Yes. In the meantime, we'll file affidavit.
Not necessary. The moment he says that, that is enough. I wanted therefore these two things. Otherwise, he doesn't have a right of.
Yes, my lord.
And if he has, this is this. List this matter again on Friday. It has been also mentioned that an interlocutory application has been filed
today
in the present proceedings. The registry shall also tag the said interlocutory application along with the instant proceedings on Friday.
Again, not the, let it be Monday or Wednesday.
On Wednesday, I have a problem with
Then let it be Monday next week.
Monday. It'll be Monday.
Obliged.
Meanwhile, they'll not take any percent at least.
My lord, they have come after what, 2 months, my lord.
No policy mention means what? They have already cancelled. You take care, who is preparing for SEBA?
सभा छुट्टी है ना कि?
Is the standing council?
Name has been shown. Why not shown? The education is.
It has been done by whom? SEBA.
Said.
SEBA is a party.
He'll give a copy. Seba is a party.
বর্তমানে সেবা নাই with the name change. Nowadays সেবা is changed.
We do one thing. No, I continue.
I think our respondent number 1 has been served as I've given.
No, we do one thing. Don't worry. Let us take. We issue notice. Returnable on next Friday. 16th. Next one. Issue notice making it returnable on 16/2/2026. There's a standing council now. It has been brought to the attention, Mr. J. Hendik appears on behalf of the respondent number 3. Who appears for the inspector of schools?
Education department.
Inspector of schools? Schools, any department, any person? Inspector of Schools and number 5, Regional Office of the Assam State School Education Department. This is against SEBA.
Now, earlier Seva, nowadays name
Now
change.
they call it Assam State School Education.
Earlier Seva.
Okay, so Mr. Have you seen Mr.
5?
Now 1, 2, and 5.
Yes.
1, 2, and 5. Who appears for 2, 3, and 4?
Dominate. Okay. 4, 1, 2, and.
Lekhok. Issue notice making it returnable on so and so.
1 and.
It has been attention has been drawn to the fact that the Assam State School Education Board has 3 standing councils, namely Mr. Torun Chandra Sutia, Mr. Nityananda Upadhyay, and Mr. Diganto Roy. The petitioner herein is directed to, the counsel for the petitioner is directed to effect 3 copies of the writ petition to either of the 3 councils who are standing councils of the Assam State Education Department, as they were to appear on behalf of the respondent numbers 1, 2, and 5. Mr. J. Hendik accepts notice, appears on behalf of the respondent number 3 and 6. Hey, anybody from school education? School education, Assam school education. Okay, Assam state, no. School education is there. Inspector of schools will come under which?
Education.
Secondary education.
Say, secondary. Elementary.
Secondary.
R. Bora is there, na? Rashmi Bora. So and so appears on behalf of the respondent number 4. extra copies of the writ petition be served upon them during the course of the day. The grievance of the petitioner herein is the order dated 2011-2025, whereby the respondent number 2 had ex parte passed an order without notice, thereby affecting the petitioner's right to the counsel appearing on behalf of the respondent numbers 1, 3, and 5 are directed to apprise this court on the next day as to on what basis the proceedings which led to the order dated 2011-2025 was initiated, and whether any notice was issued to the petitioner prior to passing of the order dated 2011-2025. Six.
Health here.
Bargain precision of birth for success.
Oh.
Birth certificate issued by the health.
Okay, health, B. Google. Yes, Mr. Sheikh.
That permission matter matter.
Huh?
Lordship will come to is 90.
Directly to dispose of the application bearing number by issuance of the NOC and so and after hearing the parties so and so.
The acknowledgement is 19.
Issue notice making it returnable on Second of March 2026. Ms. So-and-so accepts notice on behalf of the respondent number 1, and Mr. J. Hendig accepts notice on behalf of respondent number 2 and 3. The grievance of the petitioner herein is that the petitioner had applied for the no objection certificate online on 15/1/2025 in the Seva Setu website and received an acknowledgement slip for the same bearing NOC/33/64545/2025 dated 15/1/2025. The grievance of the petitioner herein is that in spite of a passage of more than a year, the NOC have not been issued, which is contrary to Section 21A of the Registration Act as applicable to the state of Assam.
Lordship, may I kindly see the page 19, Lordship. See, the mobile number. The mobile number which has been, my lord, given in the, my lord, that in the, my lord, that Seva Setu, my lord, is something different. My lord, this message have to be go this into this mobile number, Lordship. Now the in the affidavit, Lordship, may I kindly see the his phone number, Lord. Something is different, Lordship. That's why he did not receive any, my lord, information regarding that.
Where the affidavit?
Affidavit page 8, Lordship.
He may have 2 numbers.
Lordship.
The respondent shall apprise this court on the next date as to why the petitioner's application have not yet been considered and disposed of. Same order. এটা আজি ডিসপোজ অফ করেছিল আই থিঙ্ক শিবানিক দিছিল নে কিবা এটা আরপি শর্মার কেস Yes, Mr. Bhattacharya. Evicted?
One part of the prayer was
They are in some rehabilitation, that is why they have come. What has happened, your lordship, they have been living there for.
Why you are asking for setting aside of the eviction notice there?
That, your lordship, I am not pressing, your lordship, that's true.
Ma'am,
In fact, your lordship, they have been there and your lordship, they have been paid duty by revenue, your lordship. Then, your lordship, there some of the petitioner name has been recorded with the Jamabandi, your lordship, as an occupier, your lordship. And they are purely on the assumption that these are revenue land, your lordship. Ultimately, your lordship, they have issued notice, they came before this honorable court. Ultimately, honorable court passes an order, your lordship, directly to dispose of their representation.
what has happened to the division bench matter?
Lordship, that is going on.
Well, it has
My
been reserved.
prayer- My prayer is
That division bench which they have assailed before the Supreme Court, my lord, it was heard on 6th of this month and hearing concluded and judgment reserved.
Which one? Before the Supreme Court?
Yes, my lord. 251.
Now my prayer, your lordship,
It's-
is limited.
Senora.
The eviction conducted, your lordship, ultimately,
It-
and
it-
they are out. Now, your lordship, if some rehabilitation can be done, your lordship, we will apply, your lordship. And even when, your lordship, we have applied earlier, your lordship, in Bosundhara, but the Bosundhara, they rejected the claim, saying that we have not been able to prove. Even there, they have not said that it is forest land. Be that as it may, eviction has been done. This is only or that prayer remains, your lordship.
Another judgment has been passed recently by the division bench?
Lordship will find the 251 and 252. Lord, the
No,
heading,
no,
my lord.
no. These are all matters. And another recent judgment has been passed pertaining to what do you call rehabilitation. These are matters. I was
This is one method, your lordship, in respect of this Gauhati, your lordship. TB hospital.
TB hospital. Yeah. What has happened there?
That your lordship dispose of directing the authorities to consider the case of the petitioner for, I don't have right now the order.
For
For your lordship, giving settlement of land.
some other land.
Some other land.
Isn't that a claim for rehabilitation?
Yeah, that was your lordship for, initially they have challenged the eviction process, your lordship.
Here also you have challenged this.
Challenge, but your lordship, that prayer, your lordship, I have not received.
Then-
Only that charge. Your lordship.
Now, how did the division bench deal with that rehabilitation issue?
That, your lordship, I will have to go through it. I can bring it, your, I have the copy.
In fact, the order sheet which I have handed over, my lordship will find one matter has been detagged. That specific, it is from Golaghat. They have
No.
That-
Mr.
they have
Gogoi,
asked
Mr.
for
Gogoi,
rehabilitation there.
that judgment of the division bench have been passed sometime in the month of November or December.
my lord.
So therefore, this is new.
This is
This is an old one. This is of only for order of
These lands are
18.
forest land. These are
This
reserved
is for
land.
forest land.
TB.
No? This is also forest land.
the forest land.
That's the difference.
Okay. Oh,
But you
that is.
But
So
your
here you want rehabilitation.
Lord, only ground your lord says that all along they are under assumption that these are revenue land. The authority has taken your lordship and received Tozibahi revenue, your lordship. And there are some of the petitioners' name recorded in the Jamabundi, your lordship.
So did you apply under Basundhara?
Bosundhara we applied. They are rejected on the ground, not on the ground that this is forest land, rejected on the ground that we have failed to prove that we have been here for 3 generations, your lordship.
Obviously.
No, that is not correct, your lordship.
No. This has been done in view of that 2016 Act.
2019 land policy.
No. 2016 Act.
Yes.
Forest 2006, I suppose. 2006 or 16. That person in the
Forest Act, your lordship.
Forest Dwellers Act, my lord.
Forest Dwellers Act.
Yes.
Your lordship, this is
Forest Dwellers Act says that either if you belong to the ST, it's
SC?
okay.
or 3
But
generations.
or if you are a forest dwellers, you have to be three generations.
generations.
Then only you
75
get
My
it.
lord.
So therefore they rejected that you can't be because of the
No, you
fact that
see.
But anyways, how an application under Vasundhara would be affected, permissible in a forest land?
No, that is not, we are on.
Because there, if you go as per forest land, the only way of settlement is to be done as per the rules of the 2006 Act. Whereby there is a Gram Sabha, the Gram Sabha will do all this. So therefore, there's no rights. So you want to go outside now and.
We are already out.
Okay, now you want it where?
Your Lordship, any place, Your Lordship, that they can, Your Lordship.
You were in Gwalpara.
Lordship, Dukumari, Your Lordship.
Give him in Gulaghat.
No. Pathia.
Give him land in Gulaghat. Okay. You should notice.
Not Gulaghat, Your Lord. Not Gulaghat. Again, we'll have to come back.
Harbianglam then. You should notice returnable on 23rd of March 2026. Mr. D. Gogoi accepts notice on behalf of the respondent numbers 1, 2,
6.
6. Ms. P.R. Mohanto accepts notice on behalf of the respondent number 3. Mr. J. Hendrik accepts notice on behalf of respondent number 4,
5 and 7.
5 and 7. Extra copies of the writ petition be provided by tomorrow. The case of the petitioners herein is that in pursuance to an eviction notice dated 6/11/2025, the petition issued by the Divisional Forest Officer, Gwalpara Division (T) Gwalpara, and the eviction notice dated 7/10/2025 issued by the Divisional Forest Officer, Gwalpara. The petitioners have already been evicted. Under such circumstances, Mr. Bottaku, the learned counsel appearing on behalf of the petitioner, at the outset submits that the challenge to the eviction notices no longer stands. Be that as it may, it is the case of the petitioner that the India being a welfare state, right to shelter is also a right to live with dignity, which comes within the ambit of right to life under Article 21 of the Constitution. He therefore submits that the respondent authorities ought to have therefore considered rehabilitation of the petitioners in some other area by issuance of settlement. Full stop. Nothing in that regard have been done by the state respondents, and being aggrieved, therefore, the petitioner has approached this court. The respondents herein, more particularly, now it will be the Revenue Department. The Revenue Department shall apprise this court as to whether the petitioners in the facts and circumstances of the case can be rehabilitated by filing the affidavits on or before. Next date, Kiman? 23rd, na? On or before 12th of March 2026. Liberty given to the petitioner to file reply thereagainst.
I seek apology, my lord, before going to the case, my lord. I would just, should I, go, my lord, I have taken error regarding the translation copy of an NA. I have the correct one in my hand, my lord. In a quantity, it was second source, it was 5, my lord. Regarding an exactly, the particular, the translated copy was like the error, my lord.
Is the notice issued under? Where is the notice?
Yes. Is
to inform you that a road is being constructed under so and so upon air route and the right to air. You are therefore directed to vacate then clear the land of the road by so and so. If you fail to do so, compelled to evict you under 18.6. 18.6 is what? What? This notice doesn't appear to be proper, no, Mr. Counsel?
So particular is at page number 42.
42.
Madam, this is the
Really?
matter.
ठीक है अपना देख दिया हो या অহা হয় 2/2026 তারিখ হয় রাতিপুৱা 10:30 বজাত ভিতৰত ৰাস্তাৰ মাটি বেদখল roadside land.
Yes. It's a roadside land minor, but it's a patta land minor. And the original road was destroyed in minor flood and a big cutter was middle of the road minor. Thereafter, they've taken steps to.
What constructed under MMUPP? What is that?
MMU minor project.
Huh?
It's a scheme.
Okay.
So we made a application for demarcation before construction of the road minor, and direction was given by the district commissioner of the circle office.
So they have not acquired any land from you?
No, my lord, no process has been done. And already, my lord, my structure was demolished, my lord, and construction is going on.
Now?
It was not completed yet, my lord. On 5, the notice was issued on 4/2, my lord. On 5, notice was served to me.
So this notice does not mention, Mr. Gusami, why the notice does not mention the area?
Because it is roadside land also, it is government
So
land.
maybe the roadside land also is in front of the High Court also. But the question is, isn't it required to mention in your notice the area which you are doing the or trespassing into? Isn't it the most vague notice? And more particularly, if the petitioner has a patta land, without acquiring the land, can you do that?
It is not patta land also, it is government.
How do you know?
I had some telephone instruction also.
What is your instruction?
That circular officer told me that it is government land also. It is government land also.
I made an application, my lord, for demarcation of land.
Okay. So what is the telephonic instruction?
He told me it is government land also.
And
roadside land also.
Eviction done?
Done. Yes.
Eviction completed?
Also, it is in the petition also mentioned.
Yes, ma'am.
Yes, in the.
My lord, erection has been done, and now road is constructed, working is going on. On 5, notice was served to me. On 6, eviction was done, my lord, before I could approach the honorable court, my lord. Hurried manner this was done, my lord. Even I was not given any opportunity of hearing, my lord. Earlier, I had made an application for demarcation before construction of one. That was also, my lord, kept in advance, my lord. And there is the direction of the district commissioner of the circle officer in this regard, my lord. I have annexed that letter, my lord, with my application.
Okay. But you see, this type of notices cannot be encouraged.
Not.
So we set aside this, return him the land immediately. You cannot have these type of notices. Notices have to be specific. You may take half of his land.
I know this is government.
This is too vague a notice. Whatever may be. If it's a roadside land also, don't you think that a notice is required? You have only asked him to vacate. That too when his petition is pending, which was submitted on 10/4/2025 and has been forwarded. Have you looked into that? We have it on Friday.
What?
Issue notice. provide how much area and have to consider what is your file an affidavit by through the circle officer. Issue notice making it returnable on 13th of February 2026. So and so appears on behalf of the respondent number 1. So and so appears on behalf of the respondent number 2 and 3, 2, 3, and 5.
Number 4 and 6.
Mr. N. Goswami appears on behalf of respondent number 4 and 5, 6. The petitioner herein is aggrieved by the actions on the part of the respondent authorities, more particularly the respondent number 6, in carrying out an eviction from the patta land of the petitioner in the name of roadside land. The learned counsel appearing on behalf of the petitioner submitted that on the earlier occasions also, the petitioner had submitted an application seeking demarcation of his land to the extent as to whether the petitioner had trespassed into the land reserved for roadside construction. The learned counsel submitted that this very application was also forwarded by the respondent number 4 to the respondent number 6. But the respondent number 6 did not take any steps in that regard. And a notice was issued on 4/2/2026. And thereby, which the petitioner received on 5/2/2026. And on 6/2/2026, the petitioner had been evicted. The learned counsel appearing on behalf of the petitioner further submitted that the said aspect not only violates the principles of natural justice, but also the law as laid down by the learned division bench of this court in the case of Muhammad Salakuddin versus the state of Assam, reported in so and so. We'll have it on Monday, 16th. Taking into account the above, this court is of the opinion that this court have also perused the notice dated 4/2/2026. And it surprises this court that the said notice is vague, inasmuch as there is no mention as to the area where the petitioner have encroached. Or for that matter, how much the petitioner has encroached into the roadside land. The counsel appearing on behalf of the petitioner submits that on the basis of this eviction being carried out, steps are being taken for the purpose of construction, and as such, certain interim directions may be paid. This court, having considered the said aspect, is of the opinion that the petitioner herein is entitled to certain interim directions till the next date. So accordingly, this court therefore directs the respondent number 2, 3, and 5 not to carry out any construction over the area of the land from where the petitioner have been evicted pursuant to the notice dated 4/2/2026. File an additional affidavit. At a line like the counsel appearing on behalf of the petitioner submitted that that the typed version of the impugned notice dated 4/2/2026 submitted that the applications were submitted by the other one is also wrong.
But
The counsel appearing on behalf of the petitioner submits that the translated copies of Annexure,
3 and then notice count.
Annexure 6, Annexure 3 and 6,
Five.
on account of urgency, may not have been properly translated. He therefore submits that he may be permitted to file an additional affidavit bringing on record the proper translated copies of the said documents. Taking into account, the petitioner is given the liberty to file an additional affidavit bringing on record the proper translated copies of Annexure 3 and 5. It's okay.
Yeah.
line लिखी दी वो, हाँ? Mr. So-and-so B. Chaudhary, who appears on behalf of the respondent numbers 2, 3, and 5, shall apprise the said officers about the order so passed during the course of the day.
Lordship, in this case, we are supposed to file affidavit, Lordship, otherwise comment received.
There is no requirement for any action.
Yes,
It only requires the interpretation of a rule. Madam.
yes, Lordship. It may be hard
The
today.
question has to be resolved.
Yes,
Which
Lordship.
one?
But what had happened is that I was usually posted in Delhi. From Delhi, I was transferred to Kitanagar. On the 31st of January 2026, I retired. So as soon as I retire, right accrues in my favor under Rule 40, subclause 2, which is at page 102, according to which I am entitled to retain my past accommodation for a period of 6 months.
Why the matters come up before me?
Yes, Lordship.
Issue has been, notice has been issued.
Notice has been issued.
Understood. Why the matter has come up before me?
It was fixed.
Oh, because I fixed it
Yes,
at 2
Lordship.
p.m.
Yes.
Anyways, what do you want?
Lordship, it may be hard today, Lordship, because.
Can be disposed of today.
Yes.
Can be disposed of.
Then?
But I derived my right from a statutory rule 40 subclause 2 at page 102, It has neither been modified nor amended nor struck down till date. And my learned senior is relying on an OM dated 6/10/2022, which is at page 72. It's an office memorandum. That office memorandum does not govern my case because my case arises post-retirement.
You're retired?
I've retired on the 31st of January, and she's relying on an OM which governs transfer postings.
You are there. You are properly, you are now in, because of the interim order, there is no problem.
Not as on date.
Fantastic. Why have you not filed affidavit?
Lordship,
Or you don't want to file affidavit?
No, Lordship, otherwise received, Lordship.
No, my question is, do you want to file the affidavit or not? Say you don't want to file the affidavit. no problem.
It may be taken up, Lordship, on the basis of the.
So you don't want to file an affidavit? Okay. Miss RDB, the learned CGC.
Page 76.
RDB, the learned CGC submits that the respondents herein, though granted an opportunity by this court by the order dated 31/2026 at paragraph number 9, would not like to file an affidavit.
Otherwise received,
No,
Lordship.
I'm not going to do that. I have given you, under the opportunity is given to the respondents to bring on record the stand by filing affidavit on or before 6/2/2026. You say that you don't want to file.
On facts, Lordship, otherwise comments has been given, but it is on the basis of policy decision, Lordship, this.
Whatever may be, but you have to file an affidavit. You don't want to file an affidavit, I'll record it.
Lordship, on Thursday, it may be fixed by tomorrow.
No, Thursday there's other matters. We'll have it on 17th
17th.
at best,
Lordship.
at 2 p.m. if you want to file an affidavit.
Lordship.
Ms. RDB, the learned counsel appearing on behalf of the respondents, submitted that she has already received the parawise comments and would be filing the affidavit on or before 13th of February 2026. Liberty given to the petitioner to file reply on or before 18th of February 2026. List the matter on 19th of February 2026 at 2 p.m. for final disposal interim order passed earlier shall continue till then.
Right.
Who? So you are appealing for 1 and 2.
I am for 3.
Who is appealing for 1 and 2?
For respond number 6, NBCC.
Assam State Warehousing Corporation and Managing Director. Who is appearing for Assam State Warehousing Corporation? They will appear for FCI only. They file affidavit. Where? Oh, affidavit in opposition filed on 26/11. Then there was this matter was dismissed for default. Okay, then not necessary. Okay.
This IA, my lord, listed. Because this infraction, because the IA is for vacating, that was already vacated by the application filed by that. IA is filed by GBM3.
No, NBCC.
NBCC.
Yeah, we had filed the IA, Lordship.
But for vacating, this was already vacated. So there is no order needed to pass it.
Yes.
Or this is infraction. Main case also will not have. Anyway, if the lordship wants it, then it is there.
But we have already handed over the entire version to FCI.
These works have been completed, Master.
Yes, Lordship. We have already handed over.
Then
the
what
warehouse.
happens?
So nothing remains,
Pay the
Lordship.
running bills of the petitioner for the works already carried in. No, only as regards the 1 to 5. Prayer A may remain.
My lord, in fact, what happened, there is a suit filed by them, my lord,
Correct.
which is pending.
Yes, civil court.
Civil time.
Okay. This court has duly perused that all the respondents have filed their affidavit in opposition. And under such circumstances, the question of service of notice upon the instant matter being pending for service of notice does not arise. More particularly, in view of the filing of the affidavit in opposition by the respondent number 1 and 2 on 26/11/2013. Mr. P.K. Roy appears to the senior counsel assisted by so-and-so appearing on behalf of the respondent number 3 and 4. 3 to 5 submitted. The instant petition has in fact become infructuous as nothing remains. In addition to that, the senior counsel also submitted that the petitioner had also approached the civil court in respect to the said
ASWC, Assam State Warehousing.
against the respondent number 1 and 2 claiming certain dues. Pusto. Mr. So-and-so appearing on behalf of the petitioner submits that he has no instructions. Pusto. List this matter again on 18th of February 2026 for admission. Pusto. Mr. So-and-so shall obtain instructions as to whether the petitioner herein would like to proceed with the instant proceedings.
For 18 any day.
Not
Or
possible.
after
18 next.
23.
No accommodation for senior counsel. Yes, what is this? Why the division bench matter is before me?
This was wrongly listed before the honorable division bench. This is supposed to come up before bench 3. Connected matter is already fixed on 23rd. It can be taken up.
Then why it is before me?
Only just for orders, Manu, because.
I'm bench 5. What are you asking for? You have also become similar like Mr. A.K. Purkast, making the petition 80 pages. Huh? That's a big petition. Why? Shall not be issued to set aside and quash the proceedings of appeal number so and so. Why do you want the quashing of our proceedings here? Huh?
Proceeded after the maximum order here. PRP has proceeded and passed an order also. That is an order time to consider.
The release of money will come before your lordships. That already is secured, which has been passed on payment. Nobody decided the first judge, 14/12/2022. That order is here. Page 8. It has gone ahead, cited with. Error 39. And the final order shall not be executed or implemented.
You are appealing for?
For a meeting with the private party, respondent number 9, we were in interim management of the tea estate during the time it was pending auction, but our cause
You are for?
separately, providing for something, was forbidden provident. I'm the commissioner.
And then?
We have filed a connected writ petition challenging imposition of dues, which were out to have been paid to us. So this is a connected writ petition.
But this is a bench 5 matter. This is not bench 3. Why did you say bench 3?
The bench 4 matter.
Bench 4? Can't be. The bench 5 matter. Bench 4 doesn't come.
Because the connected issue was listed before bench 4.
Okay, we pull that also. Detect. Okay, we do one thing. Is an interim order?
Yes, there is a.
What to do? Urgency, no urgency.
Still on 23rd, the other cases also coming up. 23rd of
No,
February.
no, so early. Okay. At the request of the parties, matter stands adjourned to be listed on 23rd of February 2026. The instant repetition be detected and the records be sent to the. So this is not being tagged on that.
This was tagged with some other.
Understood, but this has been detected by the division bench.
No, these were some other petitions which it was wrongly tagged with. Therefore, we have to detag it, then it was listed before lordship today.
But why you are saying that it has to be tagged with another one?
Petition which is not part of this two.
Okay, on 23rd.
Just on 23rd.
Interim order passed earlier shall continue till the next.
Addition item 24.
What is this? This is custodial violation. So you are appearing. Everything is complete. Affidavit filed by 10/11. Have you filed reply? You want to file reply? Yes, Ms. Hazarika, you are appearing for whom?
Respondent number 7. One of the persons who
You have filed your affidavit?
No, not of the, in fact, I did engage only yesterday. No application filed. And the certificates have been pointed out to Lordship, they have also filed a complaint, criminal complaint. That was registered and the session judge passed an order imposing certain fines on me and 6 months imprisonment. That is not on record. I'm putting that into record. As against that order, Lordship, a plea has been filed by me as well as by the petitioner. Now that appeal is pending before the High Court. So whether there has been seen anything, the criminal matter has not come to an end as yet. But so now that criminal cases have to be decided first before this can be taken up, Lordship. Because even they had gone to the Human Rights Commission. Human Rights Commission was of the same opinions in the criminal matters pending regarding whether he's guilty or not. Unless that is proved, where can the question of compensation from him or any other thing come up? I would like to file a short affidavit.
But Ms. Hazarika, I don't accept what you are submitting because of the fact that here the right is of a constitutional thought.
Right.
On the other hand, the criminal will follow on its course in terms of 357A.
So, Lordship,
we have nothing to do with
Lordship,
that.
whether there is.
Don't clarify. You take your seat.
Lordship, I may be allowed to file an affidavit.
You have not filed your affidavit.
Lordship, I've been
and this is a very allegation is against you. You have not filed an affidavit. And mainly because the senior counsel have been now appointed, does it mean that you will be given the liberty to file an affidavit?
Lordship,
It's a matter of 2014.
Lordship has
Now
sought,
you argue.
Now,
Lordship has sought this.
Argue.
Lordship, I want to clarify the submission made
Argue.
by the senior counsel, Lordship.
Yeah.
The criminal matter which has been.
Criminal matter, forget about this.
Yes.
Whether you are entitled to
Yes,
constitutional note,
yes.
tort or not. Argue.
The basis against which we have approached the custodial violence. And that has been proved by the trial court. And this police officer has been convicted for 2 years and 50,000 compensation. And the criminal appeal is pending before this honorable court.
And that is material.
And there is another contempt petition has been initiated by this honorable high court against these persons, and that contempt petition was disposed of, stating that as the criminal court has already convicted, so he has not been prosecuted again. So, and in that contempt order also, it has been stated that the petitioner has the liberty to approach under 226 for getting compensation on the basis of the violence committed on him. And we approached here challenging Lordship's order of Human Rights Commission, prayer person criteria. Human Rights Commission order dated 29/9/2013, wherein they have not, they have proceeded against the case as criminal matter is pending.
Page. No, we are not concerned there. If the Human Rights Commission does not act as per law,
Yes.
we are not stopped from acting.
Yes, Lordship.
And there is no reply. So we will deem that whatever you have stated has been admitted.
Prayer point number 3, page 31.
So on the basis of the judgment passed by the learned by the trial court.
Yes. But that is not the basis. Before passing of this trial court judgment, we have.
8. On the basis of the judgment passed by the trial court, he does not get a benefit now, because in view of the recent judgment passed by the Supreme Court, that once a judgment has been already passed, maybe an appeal has been pending, it's a different thing, then he does not get the benefit which a person otherwise gets when a trial is on. So once a conviction has been done, it is there. As the appeal being filed, it's a different thing. That's a different aspect of the matter. Be that as it may, when there is no reply filed, by 7 and 9, let us go as per the doctrine of non-traverse and dispose it off.
Then Lordship, prayer number 3, compensation.
Okay, heard, Mr. Your name?
Lordship, I will be highly prejudiced.
No, you are not prejudiced. Because of why are you prejudiced?
Because
of
at least
the
Lordship
fact
will
that
hear
you
me.
have been engaged now. A matter of the year 2014.
Lordship,
12 years have gone by. Isn't it the most shameful? And now you say after 12 years, I want to file an affidavit. And
Lordship,
because I've
only
been
now.
recently engaged.
Lordship, 3 days time won't matter, Lordship. Let it come up on Friday.
This is a huge.
Let it come on Friday, Lordship.
Not done. Why haven't you filed an affidavit? You are waiting till the matter comes up before the court, and this court directs. The last time the matter came up is on 31/3/2023.
So, Lordship, right?
Goodness, this is very sad. The person has died. After
No.
filing, the person has died also.
Not in custody, Lordship, not in custody.
And how much compensation you want? 50?
More than that. And there is Lordship, another prayer. There is no departmental proceeding till date conducted against these police officers. Against the one who.
So how much do you want?
Departmental proceeding.
How much do you want?
I leave it for.
And then 50, I said 50, you are saying more than that means? How much do you want? And how much? I was saying 50 lakhs. This is custodial interrogation or death.
No, interrogation.
Torture, inhuman torture has been committed on him, and after 2 days.
And is this officer still working?
Still working, no departmental proceeding.
Oh my goodness.
That time.
How is it possible after a conviction? And what is your government stand? Who is appearing for the government? What is your stand? The government has not filed affidavit.
No, sir.
So they also admit what you are saying. Well, who is respondent number 10 and 11? Gauhati Medical College and Registrar General. What is Gauhati Medical College saying?
Just file affidavit.
And you? What is your stand? Okay. I have heard Miss N. Chaudhary, the learned counsel appearing on behalf of the petitioner. Who's- Who appears for the other state department, Ministry of Home. Mr. J. Hendick appears on behalf of the respondent numbers 1, 2, 1, 2, 4, 5, 6, 6, 14, no, 6. Ms. M. Hazarika, the senior counsel, appears on behalf of the assisted by so-and-so, appears on behalf of the respondent number 7.
7. Lordship, the two more private respondents.
Huh?
The two more private respondents.
Are you paying for all?
No, I'm not.
Only 7.
I'm only 7. 8 and 9 is there, Lordship. I don't know whether notice.
7. None has appeared on behalf of the respondent number 8 and 9. Mr. Miss so-and-so appears on behalf of the respondent number 10, 3 and 10. Mr. So-and-so Iskedas appears on behalf of the respondent number 11, 12, and 13. None appears on behalf of the Assam Human Rights Commission. The present petition has been filed by the petitioner.
6 also no one appears, Lordship. 6. Huh?
In the year 2014,
6, yeah.
seeking various directions, and more particularly, seeking alleging constitutional tort against the respondent numbers 7, 8, and 9. The further allegation of the petitioner herein that all the respondents 7, 8, and 9 have been convicted by the learned trial court in the by the judgment dated this is one case or many cases. All were co-accused. This is the case of the petitioner that the respondent number 7 have already been convicted by the learned court of the additional session judge number 1 Kamrup Metro at Gauhati in sessions case number 165/2015. The learned counsel for the petitioner further submitted that though an appeal has been preferred and the appeal being pending, but in view of the recent judgment of the Supreme Court, the respondent number 7, the pendency of the appeal would not bar this court to take up the issue pertaining to constitutional tort. The record reveals that though that only the respondent number 10 and 11 have filed their affidavit in opposition, But the respondents number 7, 8, and 9, against whom serious allegations have been mentioned, but they have not filed their affidavit in opposition. In other words, the respondent number 7, in other words, comma, the doctrine of non-traverse can be applied as regards the respondent number 7, 8, and 9. More particularly, taking into account that the instant writ petition is more than a decade old. Considering the above, comma, this court fixes the instant writ petition for final disposal on 19th of February 2026 at the top of the list. Full stop. The respondents has the records in this case been called for in the criminal appeal? What is the number of the criminal appeal?
There is 2 criminal appeal. We have informant has filed 1 for enhancement of the punishment, and the appeal has been filed by this respondent is 7.
Which one is that?
165 filed by this respondent.
Okay. At the top of the list for final disposal.
198 and 1265.
Not necessary. We go on doctrine of non-traverse.
We filed the affidavit, Lordship.
No. Why haven't you filed?
Wait, please. On behalf of HR Ambassador, the matter has become infractions matter. As per instruction of HR, matter has become infractions matter.
Mr.
I am on behalf of.
So and so appearing on behalf of the petitioner submits that the writ petition has become infructuous in view of the fact that the petitioner have received the dues
Lordship, as
for which the instant writ petition has been filed. Taking into account the above, the instant writ petition therefore stands closed on withdrawal as it has become infructuous. What is this?
Lordship, we are a non-banking financial company registered in the year 1995 under the Companies Act.
Affidavit filed?
Yes, 5.
Okay, we take it up for final disposal. There's an interim order.
No interim.
No interim.
What is the case about?
Against the cancellation of the certificate of registration in the year 2003, madam.
RBI cancelled our certificate of registration
Then,
as an NBFC.
as?
As NBFC, we are a non-banking financial company, and they have cancelled our certificate of registration. The respondents have cancelled our certificate of registration, and for against that we moved as a writ petition with honorable court. Then we have withdrawn the writ petition also because we were instructed to go for appeal as per provisions in the act. Then we went for appeal. Our appeal was also dismissed. And later on, we applied again to the respondents for consideration. That was also not considered. Then we took many administrative steps. We written letter to the PMO office also.
So,
Now this writ petition has been filed by us, and
your appeal was dismissed as far back as on
On
not
2007,
dismissed.
madam.
2007.
Yes.
uh,
No, madam.
Appeal.
The appeal was dismissed. in the-
appeal was dismissed.
Then,
Appeal was
thereafter,
dismissed.
filing representations who did help you. No case. This is not a case for fit for urgency. Also, taking into account the pleadings are complete, comma, list the matter for admission again on 10th of June 2026.
Lovely.
27.
The petitioner there shall explain on the next date as to whether the instant writ petition can be at all entertained in view of the doctrine of latches, delay in latches.
Lovely.
Pune order. What is this?
We have filed the affidavit today, Lord.
Yeah.
Affidavit.
Filed
reply has been
today.
Filed today.
Who?
I had copied. the
Government lodging.
The government,
Right,
it
so
has
not
been
there, ma'am.
informed that the government of Assam
Lordships.
have filed the affidavit in opposition,
Not
affidavit
opposition
in
in terms of
reply today. However, the state is not on record. Accordingly, lists this matter on 23/2026 along with the said affidavit. Please. কিমান আছে? বহুত আছে। আৰু আছে। গৈ admission এ হৈ আছে দেখোন। কিমান আছে? Yes. Disbursement of compensation in favor of for acquisition of health insurance in Why should this court at all entertain this type of writ petition?
I claimed the protection for the government, my lord.
Huh?
From the government, my lord.
No, if you have, this is being done under what provision? Acquisition?
Land has been acquired
Under what provision?
under the provisions of Land Acquisition Act, my lord.
There are 5 land acquisition acts.
That is not that case, my lord. My case is that, my lord, the compensation amount to be divided into 3 equal share, but entire amount has been deposited in the respondent number 5 accounts. This is my case. And
Mr. Burua, I also understand that. My question is, which land acquisition act?
2006 Land Acquisition, earlier Land Acquisition Act, my lord.
1894.
That-
Sure. 1894 section 18(1) says, if you have any problem with the apportionment, you have to approach the district judge. You have to approach under section 30.
No any objection, no any advance with the compensation amount, my lord. I have no any advance with the compensation amount and the procedure, my lord. My advance is
Mr.
that-
Burua, you first read section 18. Read section 64 of the new act. 18 of 1894. Section 12 of the Assam Land Acquisition and Requisition Act. Or if it is under the National Highways Act, read section 3H4. All these 4 I'm giving you. Then come before this court. These are the various provisions. Counsel, if hearing on behalf of the petitioner seeks for an accommodation to look into the provisions under which the petitioner's land have been acquired, list this matter again on 33/2026. Yes.
my lord, there is a interim, my lord.
What interim?
There- that amount, my lord, that-
এইটো একদম শেষ করে দিনে শেষ কৰিব লাগিব এইটো 13 তাৰিখে দিয়ক 13 February. Interim order passed shall continue until the next day. Yes.
Well, item number 45 and 46 is that the Holy Child School gratuity matter.
This is not finished yet.
That has been, no,
That's a bench 4 matter
I have it listed here because your lordship directed to get the matter listed.
for compliance.
For compliance.
Has it been complied with?
It has been complied, affidavit given, everything is done, my lord. Now they have challenged your lordship's order before the division bench. So, my lord, now I'll be appearing there, but then for the information to this court, that so far as this court is concerned, the matter has ended, my lord.
Okay. So we close there.
We close.
Have you filed an affidavit of compliance? So pursuant to the directions passed by this court in the order dated so and so in so and so, this court, the affidavit of compliance have been filed, and as such, nothing further remains to be done. Which one?
Item 29.
What is this?
20.
We'll have it next week. Next Wednesday? Not this Wednesday. This Wednesday, I have some difficulties taking into account there is a big series at 2 p.m. to be taken up. So that is item on 11th. 12th, I'm sitting at 2 p.m. 2 p.m. So that is the difficulty. So Friday, Saturday, Thursday, Wednesday, Thursday, that's the problem this week. Next week, we have no problem. Did. And JN Enterprise will have it on Friday. You got the judgment? Friday.
41 maybe.
Get all these things.